What is the question we have to continue? 215. Okay. Online students, is it audible to all of you? Please give me confirmation before I can start. So we need to be little faster today to catch up with the questions. Okay. Online students, is it audible? So delimitation is a very important area this year. Last year also I think there was a question on delimitation. First, the constitution has given the parliament to make a law and to establish a body which is called as a delimitation commission. And this delimitation commission has three important functions to perform. What are the important functions? First of all, it is a delimitation commission which will determine the number of seats for every state for the Lok Sabha elections as well as the assembly elections. And what is the principle based on which all these things has to be decided is on the basis of population, and for which what population is fixed right now is the 1971 census, should not have any doubt. Okay, the number of seats is going to be based on 1971 census, and this 1971 census is likely to continue till the first session, till the first census is published, till the first census is published after 2026. Initially by the 42nd Constitutional Amendment Act it was made up to 2000, then again by 84th Constitutional Amendment Act it is extended till 2026. So the Delimitation Commission not only decides the number of seats, but the Delimitation Commission is the one which will also decide what? It will also decide the boundaries of each and every constituencies. The Delimitation Commission will also decide how many seats are to be reserved in every state for the scheduled caste and scheduled tribe. But all these things is to be done on the basis of population. So the total number of seats based on which population? 1971. But the boundaries and the seats reserved for the scheduled caste and scheduled tribe is done on 2001 census, and this is likely to continue till the first census is published after 2026. Is that clear? Now the Delimitation Commission has been given so much power that whatever is the decision of the Delimitation Commission cannot be questioned by a court of law. So does it mean that the Delimitation Commission decision is not subject to judicial review? So this matter has come up before the court. So the Delimitation Commission decision will not be questioned on substantive matter, which means if the Delimitation Commission decides these many number of seats are to be allocated, that shall not be questioned. But if there are any procedural irregularities by the Delimitation Commission in deciding that, if there is a malafide intention by the Delimitation Commission in doing that, so those things can be questioned in a court of law. So if they ask is it subject to judicial review, generally not, but in certain areas, especially as I said that they did not follow the principle of natural justice in, let us assume, in deciding the number of seats, or there is a malafide intention on the part of the Delimitation Commission in deciding the seats, these things can be questioned. So therefore you will have to look into the question statement very carefully. So in general it is not subject to, but on limited grounds it is subject to judicial review. So this is what is the view that has been taken by the judiciary. Now so far after the commencement of the constitution, how many times do you think that the Delimitation Commission has been established? 4 times. One in 1952, which is based on 1952 based on 1951 census, then again in 1963 which is based on 1961 census, 1973 based on 1971 census, and then again in the year 2002 which is to be done on the basis of 2001 census. But however, remember, the total number of seats is always based on what? It is based on 1971 census till the first census is published after 2026. Now why the southern states are having concern with regard to the Delimitation Commission now is because after 2026 if any delimitation is done, then it will be based on the census that is published. The 2021 census is not yet published, it is very likely to be published after 2026. So therefore the southern states are having a concern that if they have to decide the seats based on the latest census, then of course it may go for a reduction in number of seats of the southern states. So therefore they are not happy and they are having their objection with regard to this, which anyways the central government has to decide as to what is the principle that they will follow on all those things. Okay, so with that you just please come to this particular question. So come here. Consider the following statements regarding the delimitation of constituencies to the election to the Lok Sabha and the Legislative Assembly elections. The delimitation of seats is carried out by a specific body called the Delimitation Commission for election to the Lok Sabha and the Legislative Assembly election. Is it true? Yes, this is true. Statement 1. The Delimitation Commission is a statutory body established by an Act of Parliament, usually headed by a chairman who would be a retired judge of Supreme Court. That is also true. If you see the composition of the Delimitation Commission, it is 3 members, usually headed by a retired judge of a Supreme Court, and then they have someone who is the Chief Election Commissioner or any other election commissioner nominated by the Chief Election Commissioner as an ex officio member. And you know that the Delimitation Commission will carry out the delimitation every state wise. So the concerned state election commissioner will also be part of it. So this is what is the composition. So this is also true. Presently the Delimitation Commission redraws the boundaries of the constituencies using 2001 census. Is it true? It is talking about redrawing the boundaries, not the total number of seats. So is it true? Yes. So this is also true. What is the answer here? All of the above. Okay, incorrect they are asking, sorry. So this is again very important. You should not make this mistake, okay. So which of the following statements are incorrect? So I will just make it none of the above. Okay, so none. So the answer is option D. Okay, so please make that small correction. Okay. Okay, so come here. Which of the following bills would not lapse on dissolution of Lok Sabha? What is a general rule that should come to your mind? That if any bill has got any relation to Lok Sabha, on dissolution of Lok Sabha, the bill will lapse. But what is the exception? If the president is involved, then the bill will not lapse. Or if the bill has no relation to Lok Sabha yet, then also the bill will not lapse. Is that clear? So with that, let us try to see. All bills pending in Lok Sabha not passed by Rajya Sabha, will it lapse? Yes, it will lapse. So here it is asking not lapse. So we will just come back to that area, which will not lapse. But yes, all bills pending in Lok Sabha, this will lapse. So therefore this cannot be an answer. Bills pending in Lok Sabha passed by Rajya Sabha, will it lapse? Yes, this will also lapse. Bills pending for the assent of the president, no, this will not lapse. Bill sent for reconsideration by the president, no, this will not lapse. Bills notified for joint sitting of the parliament, this will not lapse, because who can notify for a joint sitting? The president. So this will not lapse. Bills pending in Rajya Sabha not passed by Lok Sabha, that means this is introduced in the Rajya Sabha and pending in the Rajya Sabha. So this will also not lapse. So what is the answer here? It is 3, 4, 5 and 6. Is that clear? So very simple understanding. Any bill which has got any relation to Lok Sabha is going to lapse on dissolution of Lok Sabha. What is the exception? If the president is involved, it will not lapse even on dissolution of Lok Sabha. Okay. So this is the general understanding you should have. Alright. So please quickly come to the next question. Which of the following is correct distinction between a money bill and a financial bill? So for the detailed explanation I have given in the previous class, we will directly go to the question. Well, all money bills are financial bills, but not all finance bills are money bills. Is that true? All the money bills are financial bills. Okay, so that is definitely true. While all money bills can be introduced only in the Lok Sabha with the prior recommendation of the president, the same is not true in case of finance bill. Is it true? While all money bills can be introduced only in the Lok Sabha, is it true? With the prior recommendation of the president, the same is not true for the finance bill. The same is not true for the finance bill, which means when you say that will all the finance bill also be introduced only in the Lok Sabha? No, because the financial bill type 1 should be introduced in the Lok Sabha, but not all the financial bills. So sir, completely you cannot say this particular statement to be true. So which of the options given below is are correct? One only. Okay, so come to the next question. Consider the following statements regarding vote of no confidence motion. So is the no confidence motion mentioned in the constitution? It is nowhere mentioned in the constitution. It is only as per the rules of the Lok Sabha, which is rule number 198. And remember, no confidence motion is a tool that can be used only in the Lok Sabha, not in the Rajya Sabha, because the collective responsibility is only to the Lok Sabha. The motion can be introduced by any member of parliament by giving a valid reason for its introduction. Does it require a valid reason? There is no need for any reason to be given, but the condition is it should be supported by minimum how many members? it should be supported by minimum 50 members. So that is definitely there. The vote of no confidence is regulated under Rule 198 of the Lok Sabha. Is it true? Yes. The passage of motion by simple majority would amount to defeat of the government. Yes. If it is passed with simple majority, it would amount to defeat. So what is the answer? So which of the statements given above are incorrect? So it should be 2 and 3 only. Okay. So 1 only, 2 only. I'll just make a correction. Which of the following statement is incorrect? Okay. Anyways, the way that it has been given is not right. So 1 only is the answer. 2 only. Let me put 2 and 3 only. None. So what is the answer? It is 1 only. Consider the following statements. Under the Constitution of India, it is the responsibility of the Union Finance Minister to lay down the budget in the Houses of the Parliament every financial year. Whose responsibility is it? It is the responsibility of the President. It is not the responsibility of the Finance Minister, because the key word here is as per the Constitution. We come to the next thing. It is the responsibility of the Department of Revenue, Ministry of Finance to prepare and consolidate the budget as per the transaction of business rules. Whose responsibility? Department of Economic Affairs, Ministry of Finance. So this is also wrong. The Prime Minister has the power to determine the transaction of business rules of the government as per the Constitution. Who has the power? It is the President, not the Prime Minister. Very good. It is the President who will determine the transaction of business rules on the advice of the Council of Ministers, but not the Prime Minister himself. So what is the answer here? Which of the following are incorrect? See, all of the above is incorrect. Come to next question. Consider the following statements. The supplementary grants under the Constitution raise a new demand which is not part of the budget. So for those who forget what are these grants, let me just recollect you the grants. Now there is something which is called a supplementary grant. So what is a supplementary grant? Supplementary grant is a grant which is introduced in the Houses of the Parliament, that is in the Lok Sabha, provided that any amount that has been allocated on a specific service is over. That means it is not a new service. For this service already in the budget money has been allocated, but the amount has been completed, or the whatever money that is allocated is already spent. So therefore, suppose for the entire year they have allocated, let us assume 10,000 crores, but this 10,000 crore is completed in 10 months. For the next 2 months for that particular service there was no money. So therefore, to allocate the money they will introduce what is called as a supplementary grant. So supplementary grant is not for a new service, but for a service which is already part of the budget. Okay. So therefore, what is this particular statement? The supplementary grant under the Constitution gives rise to a new demand which is not part of the budget. Is it true? Which is already part of the budget. So that is basically what is called a supplementary grant. As the name suggests, it is supplementing the already existing service for which you are introducing this. An additional grant under the Constitution increases the amount of the existing demand which is already part of the budget. Is it true? It is rather vice versa. Additional grant is for some new service which is not part of the budget. Supplementary grant is already for an existing service. And apart from that, there is also something which is called as an exceptional grant. What is an exceptional grant? See, exceptional grant is similar to that of the additional grant, but the difference between additional grant and exceptional grant is, additional grant is for a new service for that particular year, but exceptional grant is never ever in the entire history, never ever such a grant has been made. So that is an exceptional grant. And apart from that, there is also something which is called as an excess grant. What is excess grant? Excess grant is they are trying to take the permission of the house when they have already spent money in excess to what has been allocated. But however, how they are able to make money excess, spend money excess in what has been allocated? That they transfer it from one head to another head within a ministry. Suppose within the defense ministry, I gave an example, if there are 4 or 5 areas where the expenditure is to be done, in one area less expenditure is happening, other area more expenditure is happening. So wherever money is there, from there they will transfer the money to another head. But this also requires approval of the Parliament. So that is done by what is called as excess grant. Is that clear? So anyways, in this question, these are vice versa. So what is the answer here? Which of the following are incorrect? Both 1 and 2. Consider the following statements regarding the Legislative Council under the Constitution of India. Statement 1. The Legislative Council can be created and abolished by an act of Parliament by special majority. Is it true? It requires just a simple majority, but however, please understand it can be done only on the basis of a resolution that is passed by the concerned Legislative Assembly. And what is the majority with which the Legislative Assembly has to pass? It has to pass with what is called as special majority. Okay. So this is definitely wrong. The Parliament can create or abolish. The Parliament can create or abolish only based on the resolution passed by the concerned state legislature. Is it true? That is, the Parliament can create or abolish the Legislative Council only on the basis of resolution passed by state legislature, concerned state legislature. But to be very specific, it is state legislature or Legislative Assembly. It has to be very specific assembly. So therefore, it is wrong. Okay, it is not the state legislature. When I say state legislature, then it has to be passed by the council also, because it is about abolishing also. Suppose let us assume already existing council is there. To abolish that, you need not need the approval of the council. Okay, so please be very careful about whether what kind of word is used. Which of the statements given above are incorrect? Both 1 and 2. Is that clear to all of you? Why this is wrong? Both 1 and 2. Which of the following is the expenditure charged on the Consolidated Fund of India? What does it mean by the charged expenditure? It is not put to vote during the vote on demand for grant stage. But can it be discussed? Yes, it can be discussed. So where it is mentioned for the union expenditure, when it comes to charge expenditure, it is mentioned mostly in Article 112 and maybe in other provisions of the Constitution and also by a law made by the Parliament. Okay, so what are the expenditures here to be charged expenditure? The emoluments and allowances of the president and other expenditure relating to his office. Yes, it's a very important expenditure. The salary allowances of chairman, deputy chairman of the Council of State, speaker, deputy speaker of House of People. Yes, this is also charged. Salary allowances and pensions payable to the judges of the Supreme Court and High Court. No or yes? How many of you think no? Salary allowances and pensions payable to judges of Supreme Court and High Courts. When it comes to the High Court, the pensions are payable from the Consolidated Fund of India, but not their salaries. Salaries are payable from where? Salaries are payable from the Consolidated Fund of the respective states. Okay, so therefore this particular statement is wrong. Why this is mistake is coming, I don't know. Salary allowances and pensions payable or in respect of the Comptroller and Auditor General in India. What about this? So this is true. For the Comptroller and Auditor General, it is charged on the Consolidated Fund of India. So what is the answer? 1, 2 and 4 is right. Okay, so I'll just make a small correction here. 1 and 2 only. 1, 2 and 3 only. 1, 2 and 4 only. All the above. So please make a correction, so therefore in the future when you revise it, you should not have any problem. So what is the answer here? It is option C, that is 1, 2 and 4 only. All revenues received by the union government by way of taxes and receipts for the conduct of government business are credited where? Consolidated Fund of India. So what is credited into the Contingency Fund of India? Nothing will be credited into the Contingency Fund of India. Whatever is the money from the Consolidated Fund of India, during the budgetary process, they can allocate some money to the Contingency Fund of India. Otherwise, nothing specifically gets credited into the Contingency Fund. What is there in the public accounts of India? All the money that belongs to the public. Say for example, the public pension funds, the savings that they make from post office savings, other schemes that the government may bring in. So these all get into the public accounts of India. So to withdraw the money, to appropriate money or to take money from the Consolidated Fund of India, please have an understanding, does it require an approval of the Parliament? Even to take a single penny from the Consolidated Fund of India, it requires approval of the Parliament in the form of what is called as an appropriation bill. So what about taking out money from the Contingency Fund of India? So that is at the disposal of the executives. But however, once the money is over, once the money comes into the Contingency Fund, it is at the disposal of the executives. But if all the money is existed, then again you will get money from the consolidated fund to the contingency fund, which requires an appropriation bill to transfer money from the consolidated fund to the contingency fund. What about the public accounts of India? In case of public accounts of India, it is at the executive disposal. That does not require the approval of the parliament. So what is the answer here? All revenues shall be crediting into what is called as the consolidated fund of India. And among the three funds, which is a constitutional fund, consolidated fund and the public accounts of India, whereas the contingency fund of India is created only by an act of parliament. Okay. What is? Judicial deposit. The judicial deposit is normally during a case and all those things, they ask the petitioners or the respondent to deposit something for the security. I am not sure where does it come, the judicial deposit. Okay. When the annual union budget, have I discussed the previous question? Okay, so come to the next question. When the annual union budget is not passed by the Lok Sabha, so what does it imply when it is not passed by the Lok Sabha? That means it will amount to what is called as a no confidence motion. It will amount to defeat of the government. So therefore, what is the answer here? The Prime Minister submits the resignation of the Council of Ministers. So it's very, very important they get the budget passed, otherwise it is assumed that the government is not having the majority. Come to the next question. Regarding the office of Speaker of the Lok Sabha Speaker, consider the following statements. He or she holds office during the pleasure of the President. They have nothing to do with the pleasure of the President. They can be removed only by the Lok Sabha. And what is the majority with which they can be removed? By effective majority. So this is wrong. He or she need not be a member of the House at the time of his or her election, but has to become a member of the House within 6 months from the date of his or her election. Is that true? That is not required. He or she should be a member of that particular House. So that is a mandatory condition. If he or she intends to resign, the letter of his resignation is to be addressed to the Deputy Speaker. Yes. If the Deputy Speaker is not there, it is the Secretary General Lok Sabha, but that is as per the rules of the House. By the Constitution, it is only to the Deputy Speaker. Yes. This is mentioned in the Constitution that he will submit the resignation to the Deputy Speaker, but in case if the Deputy Speaker is not there, to whom the resignation will be submitted? It is to the Secretary General Lok Sabha, but that is not there in the Constitution. That is as per the rules of the House. So this is true. So which of the statements given above are correct? 3 only. Please come to the next question. The Parliament of India. In the Parliament of India, the purpose of an adjournment motion. What is the purpose of an adjournment motion? To discuss a matter of an urgent public importance. Now, yesterday I discussed about Rule 267 also, where it is about discussing a matter of urgent public importance. While Rule 267 is only for the Rajya Sabha, an adjournment motion, as the name suggests, it can be introduced only in the Lok Sabha as per the rules of the House. Although in the Rajya Sabha also it will suspend all the business under Rule 267, but it cannot be considered what is called as an adjournment motion. The name adjournment motion is specifically used only for what? Only for the Lok Sabha. Why? Because it has a serious element of ramification for the government to answer all the question when an adjournment motion is introduced. And the government is specifically accountable to which house in the Parliament? To the Lok Sabha. So therefore, the name adjournment motion is only used in case of Lok Sabha and not in case of what is called as Rajya Sabha. So what is the answer here? To allow a matter of urgent public importance. And similarly, no confidence motion can be introduced in which house? Only in the Lok Sabha. What about privilege motion? This year the privilege motion I feel is very important. Can the privilege motion be introduced in both houses of the Parliament? Because the Congress was trying to introduce a privilege motion against Mr. Amit Shah, and it was there in the newspaper for some time. So can the privilege motion be introduced in both houses of the Parliament? Yes. Is it possible? Think about it for a moment. Of course it is possible in both houses. It can be introduced against any member of Parliament who is breaching the privilege. Not only against a member, against the non-members also. Okay, when it comes to the privilege motion, when this motion is introduced, normally this matter is referred to a privilege committee. Is there a privilege committee in both the houses of the Parliament? Yes? Yes, there is a separate privilege committee in both houses of the parliament. Anyways, there is a separate question on that. In the later part, I will discuss about it. Consider the following statements. The Parliamentary Committee on Public Accounts consists of not more than 25 members of the Lok Sabha. Is it true? It consists of only 22 members, not 25 members. This is wrong. The Public Accounts Committee, which committee is that? Okay, Public Accounts Committee scrutinizes the appropriation and the finance accounts of the government. Is it true? The Public Accounts Committee, do they scrutinize? What does the CAG do? The CAG in fact audits these accounts only, the appropriation and the finance accounts. So that is only scrutinized by the Public Accounts Committee. Is it true? Of course it is true. Examines the report of the Comptroller and Auditor General. Yes, in general the auditor report, specific they scrutinize these accounts. So all the things are true. Which of the statements given above are correct? Okay, only 2 and 3. Okay, so option B, 2 and 3 is correct. Come to the next question. Consider the following statements. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. So it can be introduced in either houses of the parliament. We have seen this yesterday. If such an amendment seeks to make changes to the federal character of the Constitution, the amendment also requires to be ratified by legislature of all the states in India. Is it not less than half of the states or more than half of the states? Not less than half of the states. Is it clear? So this is also wrong. Which of the statements given above are correct? Neither 1 nor 2. So most of the things it is getting repeated because of the previous year questions. So therefore wherever a broader explanation is required, I will give it. Consider the following statements regarding a no confidence motion in India. There is no mention of no confidence motion in the Constitution. Is it true? Yes. A motion of no confidence can be introduced only in the Lok Sabha. As per the rules of the Lok Sabha, it can be introduced only in the Lok Sabha. What is the rule number? 98. It can be introduced only in the Lok Sabha only. So this is true. So what is the answer? Both 1 and 2. Which one of the following is the largest committee of the parliament among the given things? So which of the largest committee in the parliament? It is a estimates committee. So quickly tell me, the committee on public accounts, how many members? Committee on estimates 20, 30. Committee on public sector undertaking 22. Committee on petitions. Committee on petitions. So for generally, if you see these type of committees, usually they are both in the Lok Sabha as well as in the Rajya Sabha. Whatever committee that is there in the Rajya Sabha, it has got 10 members. Whatever committee that is there in the Lok Sabha, it will have 15 members in general. But they can vary it as per the rules, but it is generally how the case. So what is the answer in this particular case? It is the estimates committee. With reference to the union government, consider the following statements. The Department of Revenue is responsible for the preparation of the budget. So it is Department of Economic Affairs, not Revenue. See, the same area is repeated in UPSC. So that is why there are only very few areas that if you have conceptual clarity, you can easily do it. Okay. No amount can be withdrawn from the Consolidated Fund of India without authorization from the Parliament of India. Yes. So this is very, very important. All disbursement made from the public accounts also needs the authorization of the Parliament. No, it is at the executive disposal. So this is wrong. Which of the statements given above are correct? 2 only. So how many of you feel that I am not remembering anything, but I am able to solve the questions? So that means I am not able to recollect and recall most of the things, but when it comes to the question, I am comfortable. So that is absolutely no need to worry about this. So this is a situation that most of the students will have. Okay, there is no need for you to remember each and everything, because of course for a human capacity you cannot remember each and everything. So but you should know the proper understanding. So therefore when it is in the form of a question, you should be in a position to solve it. Okay. Of course there are few information you will remember. It is not necessary you should be able to reproduce each and everything. Certain areas, even for the mains also, when it comes to the mains examination also, you don't have to remember each and everything. Means like you would prepare for your school or college examination, you cannot remember the entire paragraph. You will only remember a keyword. So then you should write it in your own way. So that is how you will fetch the marks. So always to crack this examination, to make the process very simple, you should have a very brief consolidated notes which is made by yourself. You can refer to number of materials. That doesn't mean you will read 10 books for a particular subject. You should restrict it to one major book. Here and there you can refer to some topics, and then you consolidate all the things, and then you keep revising the same thing again and again. Your preparation is going to become much easier. Anyways, so that doesn't mean that now I am telling you to prepare the notes. Now this is not the time to do that. If you have already done it, it is okay. If you have not done it, whatever source that you are referring to, you revise it from there itself. Okay. When a bill is referred to the joint sitting of both the houses of the parliament, it has to be passed by what majority? It has to be passed with simple majority. This is very important. Do not have any confusion in this regard, because the bill is normally referred only in case of an ordinary bill, and for an ordinary bill anyways it has to be passed with simple majority. Consider the following statements. The Rajya Sabha has no power to reject or to amend a money bill. They cannot amend it, they can suggest amendments. So appropriate word is they can suggest amendments and they can send it back. Okay. So the Rajya Sabha has no power either to reject or to amend it. So therefore this can be seen as right. They can suggest amendments, but they cannot make themselves the amendment. The Rajya Sabha cannot vote on the demand for grants. Voting on demand for grants is a prerogative of only the Lok Sabha. Okay, so this is also true. The Rajya Sabha cannot discuss the annual financial statement. Can they discuss? In fact, please understand, the budget is introduced in both the houses of the parliament and then it is discussed in both the houses of the parliament. Okay, so therefore to say that the Rajya Sabha cannot discuss the annual financial statement is wrong. Okay, so the Rajya Sabha cannot discuss the annual financial statement, that is wrong. So what is the answer here? 1 and 2 only. But the budget speech is made by the finance minister only in the Lok Sabha. Is the budget speech made in both the houses? No, it is introduced in both the houses, but where the speech will be made? Only in the Lok Sabha, but the general discussion happens in both the houses. Which of the following statements are correct? All bills pending in Lok Sabha lapse on its prorogation. It has no effect on the bills when it comes to prorogation. When it will have effect on the bills? Only in case of dissolution. So prorogation is merely terminating of a session. So therefore it does not have any effect. All bills pending in the Lok Sabha lapses on its prorogation. So this is wrong. All bills pending in the Rajya Sabha which has not yet been passed by Lok Sabha shall not lapse on dissolution of Lok Sabha. Is it true? This is true because it has no relation to the Lok Sabha. So which of the statements given above are correct? What is the answer? 2 only. Come to the next question. The Parliament of India exercises control over the function of Council of Ministers through what? So basically, what are all the mechanisms that is available in a parliamentary democracy to make the government accountable? Can they be made accountable through adjournment motion? Adjournment motion means very serious discussion. So that means it is possible to make them accountable. Question hour? Of course, they can do it through the question hour. Means question means they have to give answers. It's a very difficult thing for them to give the answers. Now please tell me that in the question hours 3 type of questions can be raised. What are the types of questions? State question, unstated question, and then there is a short notice question. Now, how is a short notice question different from the other 2 types of question? The notice time is less. In the other cases, both in state and unstated question, minimum 15 days of notice has to be given, but whereas here less than 10 days of notice. So because of the urgency, they can use this tool of what is called as short notice question. And what is the difference between a stated and an unstated question? A stated question is where that they have to give an oral answer, whereas in an unstated question it is given as a written answer for a written question. So these are all the broader things you have to remember. Supplementary questions. Supplementary question is possible in case of which type of questions? In case of stat question, where there is a oral question. So therefore they can have a supplementary question to the answers. So what is the answer here? 1, 2 and 3 only. Consider the following statements. In the election for the Lok Sabha or the state assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. Is it true? In the election for the Lok Sabha or the state assembly, the winning candidate must get at least 50% of the vote. No, it is based on first past the post system. So in the first past the post system, there is no need to get any minimum number of votes. All that they need is they have to get more number of votes than the other candidates. According to the provisions laid down in the Constitution of India, the Lok Sabha speaker's post goes to the majority party and the deputy speaker to the opposition party. Is it true? There is nothing mentioned in the Constitution. So please be very clear about this. The Constitution does not say that. The Constitution only says two things. One is who can contest the election is someone who is a member of parliament from Lok Sabha, and who can get elected or who will get elected, someone who secures a simple majority. But it is an implied understanding that the government has this majority, and if the government wants, they can get elected the deputy speaker also. But as a parliamentary convention, the post of deputy speaker is given to the opposition party, provided they have a status of an opposition party. And to have the status of the opposition party, what is the majority they should have? Not less than 1/10 of the total membership of Lok Sabha. Again, this is nowhere mentioned in the Constitution. It's only a parliamentary conventional principle. Is that clear to all of you? So according to the provisions laid down in the Constitution, so always make clear whether it is saying mentioned in the Constitution or not. Okay. So nothing is given in the Constitution in this regard. So therefore, this is wrong. So which of the statements given above are correct? It is neither one nor two. With reference to the Parliament of India, which of the following parliamentary committees scrutinizes and report to the House whether the powers to make regulations, rules, sub-rules, bylaws conferred by the Constitution or delegated by the Parliament are being properly exercised by the executive within the scope of such delegation? What is the answer here? Committee on Subordinate Legislation. So can anyone tell me what does it mean by subordinate legislation? The rules that is made to execute the laws. Say for example, recently Citizenship Amendment Act was passed. When the Citizenship Amendment Act was passed? 2019, but only in 2024 they started implementing it. Now why it took 5 years for them to implement this? Because the rules has not been formulated. Because the law says people belonging to 3 countries, belonging to 6 minority communities, though an illegal migrant can become an Indian citizen. But how do we identify they have entered only from these 3 countries, they belong to these 6 religious communities? There should be a way to mechanism to verify. Now these things are not mentioned in the law, but the rules can specify as to how these things can be verified. So only in 2024 the Citizenship Amendment rules came in. Okay, so therefore rules, and who makes these rules? Normally it is done by the executives. So that is why it is called as subordinate legislation or delegated legislation or executive legislation also. So consider the following statements. The Parliament Prevention of Disqualification Act 1959 exempts several posts from the disqualification on the grounds of office of profit. Is it true? That we'll see that, because these are all the areas it is not very clear, but see how UPSC is asking the question. So come to statement number 2. The above mentioned act was amended 5 times. That's also quite factual. We will not be able to see. But come to the third statement, the term office of profit is well defined in the Constitution. Is it well defined in the Constitution? No, it is not defined in the Constitution. Leave about well defined, it is not defined in the Constitution. So therefore, anyway statement 3 is wrong. So what is the answer? 1 and 2 only. Okay, so sometimes don't panic when you read the first statement. Try to always read all the statements and see the options as well. Okay, so that is how it becomes easier. So therefore, the Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the grounds of office of profit. Anyways, you can consider this right based on general logic also, because what is the purpose of this particular act? Is to exempt certain officers from being office of profit. So this is true. So above mentioned act was amended 5 times. So factually it was also true, it seems. The Rajya Sabha has equal powers with Lok Sabha. In what are the matters they have equal powers? The matter creating new All India service. Do they have equal powers? Do they have equal powers? So who has the authority to create a new All India service? Very good. It is not the Rajya Sabha, it is a parliament. So I have told it number of times, who has authority to create a new All India service? It is a Parliament of India. The Parliament has to enact a law by which they can create a new All India service. But the Parliament cannot enact a legislation unless and until a resolution is passed by the Rajya Sabha. So therefore, if they say who has to pass a resolution to create a All India service, it is Rajya Sabha. But who can create a new All India service? It is only the Parliament, based on the resolution that is passed by Rajya Sabha. Under which article the Parliament has the power to create a new All India service? Article 312 of the Constitution. What is the majority with which the Rajya Sabha has to pass a resolution? It has to pass a resolution by special majority, that is not less than 2/3 of the members present and voting. Clear? Okay, so with that the Rajya Sabha has got equal powers, definitely not with regard to creating an All India service. Amendment to the Constitution, do they have equal powers? Yes, because it has to be separately passed in both the houses. Removal of the government, no conference motion can be introduced only in the Lok Sabha, no. Making cut motions are during the vote on demand for grant, which is a prerogative of the Lok Sabha. So therefore all these things are wrong. Come to the next question, consider the following statements. The President of India can summon a session of the Parliament at such places as he or she thinks fit. Is it true? Not necessarily only in the Parliament, he can summon the sessions outside the Parliament as well if required. Say, think of a situation of emergency, war. So therefore you cannot risk summoning all the members of the Parliament in the Parliament. Okay. So therefore yes, it is possible for him to summon, but he can do that only on the basis of aid and advice of whom? On the aid and advice of the Council of Ministers. Under no circumstances this can be a discretionary power of the President. The Constitution of India provides for 3 sessions of the Parliament. Is it true? The Constitution does not provide for any fixed number of sessions. The only thing that is mentioned in the Constitution is that there shall not be a lapse of more than 6 months between 2 consecutive sessions, or there should not be recess of more than 6 months. That is the only thing that is mentioned in the Constitution. Is the number of days that they have to meet, is it mentioned in the Constitution? That is also not mentioned, nothing is there. So which article gives the President the power to summon the sessions in the Parliament? Article 85 of the Constitution. Very good. So therefore this particular statement is wrong. There is no minimum number of days that the Parliament is required to meet in a year. So this is also true. So what is the answer here? It is 1 and 3 only. I am sure that you are also quite clear about what is adjournment sine die, what is adjournment, all those things. According to the, consider the following statements. According to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if he or she is not a member of the legislature of that particular state. Is it true? According to the Constitution, a person who is eligible to vote, rather what is should be eligible? Eligible to contest, apart from eligible to vote. So he should be eligible to contest, and in fact eligible to contest will come only when he is eligible to vote, because one of the requirement to contest the election is what? He or she should have a eligible voter ID card, or he or she should be eligible to vote. So therefore it is not necessarily, not only the eligible to vote, but eligible to contest. So it is because of this particular statement is wrong. According to the Representation of People Act 1951, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting election even after his release. Is it true? There is no permanent disqualification. What is the maximum disqualification? Whatever is the term of imprisonment, once he is released, then 6 years. Okay, now tell me, what if the conviction is less than 2 years? On some criminal offence, let us assume there is a criminal offence of defamation. If the conviction is less than 2 years, then in that particular case, will he be disqualified? Who said? Defamation is also a criminal offence. There are 2 types of defamation. The defamation can be a civil offence also, criminal offence also. It depends upon what kind of petition that you file in a court. So defamation is both a civil as well as a criminal offence. So in a civil offence, if it is filed as a civil suit, they may look for some compensation for damaging the reputation. But if they file a criminal offence, then they can ask for the imprisonment of the individual also. So therefore, let us assume if somebody is convicted in a criminal defamation case, if the punishment given is 1 year for a member of parliament or a member of state legislature, is he liable to be disqualified? he is not liable to be disqualified. Okay, so although he may go to prison, but he is not liable to be disqualified, because what is the minimum number of years? Minimum 2 years. Okay, so then only he is liable to be disqualified. And then if minimum 2 years, then he is also not eligible to contest for another 6 years. But there are certain type of offence where they will be immediately disqualified even if they are convicted, irrespective of the quantum of punishment. That is specifically mentioned in the Representation of People Act. Some examples we have seen. Can you give me some examples? Hate speech, Prevention of Corruption Act, Civil Rights Act, terrorist related acts. So these are all something which is specifically mentioned. So with that, this particular statement is also wrong. So what is the answer here? What is the answer? Neither one nor two. Come to the next question. With reference to the Deputy Speaker of Lok Sabha, consider the following statements. As per the rules of the procedure and the conduct of business in Lok Sabha, the election of the Deputy Speaker shall be held on such a date as the Speaker may fix. Who will determine the date of election of the Deputy Speaker? The Speaker. So that is true. This is as per the rules of the House. There is a mandatory provision that the election of the candidate as a Deputy Speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. There is no mandatory provision in this. It's only a parliamentary convention that the post of opposition, that post of the Deputy Speaker is given to the opposition party. Okay, so there is no such mandate. The Deputy Speaker has a power as of the Speaker when presiding over the sitting of the House, and no appeal lies against his ruling. Is it true? When I say no appeal lies against his ruling within the House, suppose today let us assume the Deputy Speaker is presiding over the House on day number 1 because the Speaker is absent. Now day number 2 the Speaker comes and he presides over the House. Can the Speaker overrule what has been done by the Deputy Speaker? That is not possible, because at the time when the Deputy Speaker is presiding as a Speaker, his decision becomes final. That is what this means. Okay. So the deputies, that is why you will understand why the government is not giving the post of Deputy Speaker to the opposition party. So even now the Congress government has got more than 1/10 of the members, but still the Deputy Speaker is not elected, because for some reason if the Speaker is not there, who will preside over the House? Automatically the Deputy Speaker, but otherwise it will be from a panel of chairperson. So therefore those members will be from the ruling party mostly. That is the reason why the government is also not willing to elect the Deputy Speaker. Okay, so what is the next thing? The Deputy Speaker has the same power as the Speaker. Okay, this we have decided. So this is true. The well established parliamentary practice regarding the appointment of Deputy Speaker is that the motion is moved by the Deputy Speaker and duly seconded by the Prime Minister. Is it true? There is no such conventional practice. There is no such practice in the first place. So this is wrong. So what is the answer here? 1 and 3 only. So these are all distractors. Usually the students get confused with the distractors, because the initial human tendency is that we have not read it probably. So it was there, but probably we have not read it. So that is a feeling you will have. So but don't have that particular feeling, because UPSC also put a lot of distractors. If you have the confidence, okay, I have never come across this, I have prepared for 2-3 years, I have never come across this, probably it is a distractor. Okay. Especially in the areas like this, if it is coming from a not so important area which you have not studied, it's okay. But there are certain areas you have studied well, then you see that it is nowhere that I have read it. So that means it is probably a distractor. Okay. With reference to the anti-defection law in India, consider the following statements. Statement 1, the law specifies that a nominated legislature cannot join any political party within 6 months after being appointed to the House. Is it true? A nominated legislature can join within 6 months. So if you want to join, so to say cannot join is wrong. So he can join it. The law does not provide any time frame within which the presiding officer has to decide the defection case. Is it true? Yes, there is no time limit. In fact, this is one of a major criticism when it comes to the anti-defection law. All right. So give me some more time. If there is any questions, I will take it up. Online students, I will take it up. So which of the statements given above are correct? What is the answer? It is 2 only. Which of the following are the exclusive powers of the Lok Sabha? Statement 1, to ratify the declaration of emergency. Is it the exclusive power of the Lok Sabha? To ratify any type of emergency, for that matter, national emergency, be it state emergency or the financial emergency, in all the cases it has to be ratified by both the houses of the parliament. Okay, so should not have any confusion in this regard. Although ratification has to be done by both the houses, but revoking a national emergency can be done by one house. Which house? Lok Sabha alone can do it. But that provision was brought in only by the 44th Constitutional Amendment Act in 1978. Before that, the only way it can be revoked is the president can revoke it anytime on the aid and advice of the Council of Ministers. But after the 44th Constitutional Amendment Act, alternatively the national emergency can also be revoked by the president based on the resolution that is passed by the Lok Sabha. Only the Lok Sabha. Rajya Sabha has no power in this regard. What is the majority with which the Lok Sabha has to pass a resolution? Which majority? By simple majority. So anyways, to ratify the declaration of emergency, exclusive power of Lok Sabha, no. To pass a motion of no confidence motion against the Council of Ministers, yes. To impeach the President of India, no, it has to be passed by both the houses by special majority. What is a special majority in this case? Not less than 2/3 of the members, not less than 2/3 of the total membership of the house. So which of the following is the correct answer? 2 only. Consider the following statements. Statement 1, a bill amending the constitution requires a prior recommendation of the President of India. Is it true? A bill requiring to amend the constitution does not require the prior recommendation of the president. So therefore, you should always have full concentration in the examination. Even a minor lapse in your concentration for the 2 years, for the 2 hours that you do there, some element of mistakes is likely to happen. So therefore, try to have a full concentration when you do it there. A bill amending the constitution does not require the prior recommendation of the president. That is not required. When a constitutional amendment bill is presented to the president, it is obligatory for the President of India to give his or her assent. Is it true? Which constitutional amendment act has made it mandatory? 24th Constitutional Amendment Act 1971. So therefore, this is true. So statement 1 is wrong, statement 2 is correct. What is the next statement? A constitutional amendment bill must be passed by both Lok Sabha and the Rajya Sabha by a special majority, and there is no provision for a joint sitting. Is it true? Yes, they have to be separately passed. So therefore, what is the answer? Statement 2 and 3 are correct. Option B is the answer. Okay. With reference to the Parliament of India, consider the following statements. Statement 1, prorogation of a house by the President of India does not require the advice of the Council of Ministers. Now try to understand, be it summoning of a session, be it proroguing of a session, it always is based on the aid and advice of the Council of Ministers. What about dissolution? Dissolution may happen automatically by a flux of time that you have already seen, or the dissolution might happen at an earlier time based on the aid and advice of the Council of Ministers. So otherwise it may happen automatically when the time is over. Okay, so please have an understanding. So the prorogation of the house of the prorogation of a house by the President of India does not require the aid and advice of the Council of Ministers. Does the aid and advice of the Council of Ministers is mandatory to dissolve the Rajya Sabha also? Rajya Sabha is a permanent house. There is no dissolution for the Rajya Sabha. Okay, so please be clear about it. So this is wrong. Does not require the aid and advice. Prorogation of a house is generally done after the adjournment signed by, but there is no bar for the President of India proroguing the house which is in session. Is it true? It is not mandatory that the President should wait for the adjournment signed by, because the prorogation can be done by the President anytime based on the aid and advice of the Council of Ministers. But generally after adjournment signed by, he does it normally, but that is not mandatory. So this is true. The dissolution of the Lok Sabha is done by the President of India, who save in exceptional circumstances does so on the aid and advice of the Council of Ministers. Is it true? Yes. So normally he may do it on the aid and advice of the Council of Ministers, but sometimes the efflux of time also it may happen. Sometimes if there is a no confidence motion against the government, then there is no need for any aid and advice of the Council of Ministers. So these are all the exceptional cases. So this is also true. So which of the statements given above are correct? 2, 1, 3 only. With reference to the Parliament of Indian Parliament, consider the following statements. A bill pending in Lok Sabha lapses on its dissolution. Is it true? Yes, this is true. A bill passed by Lok Sabha and pending in Rajya Sabha lapses on the dissolution of Lok Sabha. Yes, it has got a relation to Lok Sabha. A bill in regard to which the President of India has notified his or her intention to summon the House to a joint sitting lapses on its dissolution. So though it has got a relation to the Lok Sabha, but because the President is already involved in the process, so therefore this bill is unlikely to lapse. Okay, so this is wrong. Joint sitting lapses on dissolution of Lok Sabha, it will not lapse. So what is the answer here? 1 and 2 only. Which of the following statement is correct in respect of the money bill in the Parliament? See, money bill, constitutional amendment bill, the presiding officers, budget, these are all areas very likely the questions are to come. Article 109 mentions a special procedure with respect to the money bill. Is it true? Then what about Article 110? Subject matter of the money bill. So this is true. A money bill shall not be introduced in the Council of States. Is it true? What is a money bill? A money bill is a financial bill which contains only those subject matter mentioned in Article 110. Therefore, such a bill can be introduced where? Only in the Lok Sabha, only with a prior recommendation of the President. So therefore, this is true, shall not be introduced in the Council of States. The Rajya Sabha can either approve the bill or suggest changes but cannot reject it. Is it true? They can suggest changes, so but they cannot reject it. The amendment to the money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha, not necessarily. They may accept or they may not accept. Most likely they will not accept it once they have decided it. Okay. So what is the answer here? 1, 2 and 3 is the answer. So what is option 1, 2 and 3? Option C is the answer. Which of the following statement is true about the ethics committee? See, last year there was lot of news about the ethics committee. So this year there is a lot of news about the privilege committee. So probably they may come also, be prepared for it. Which of the following statements about the ethics committee in the Lok Sabha is correct? Initially it was an ad hoc committee. Yes, initially when it was established it was an ad hoc committee. In 2000 I think it has become a permanent committee. So but before that it was an ad hoc committee in the Lok Sabha. So yes, initially it was an ad hoc committee, that is true. What is an ad hoc committee? Temporary committee. It is not a standing or a permanent committee. That means whenever there is a issue that is brought against a member, to study that a committee will be appointed. Once that issue is over, the committee is dissolved. Only a member of Lok Sabha can make a complaint relating to the unethical conduct of a member of Lok Sabha. So in a democracy, the members of the parliament has to be accountable to the people. So therefore, to say only the member of parliament can initiate that, it is not the right thing. Even the ordinary citizens can file a complaint to the respective houses. So therefore, only a member of Lok Sabha is wrong. This committee cannot take up any matter which is sub judice. Is it true? This is a general principle of separation of powers. So once a matter is there in the judiciary, that matter shall not be taken up by the legislature. So because to respect the principle of separation of powers. So for such questions, even if you are not aware, try to apply your common sense. Okay. So try to put it, don't just leave that particular question. So try to apply your overall knowledge. So with that you can especially get these two things right. So what is the answer here? 1 and 3 only. So even if you can eliminate 2 also, still you will arrive at the answer. That is option C. Which one? The committee cannot take up matter which is sub judice, that is true. The committee cannot take up any matter for discussion if already the court has entertained and the court is looking into this particular matter. Sub judice means already the court has taken up this particular matter, that is what is sub judice. Come to the next question. How many delimitations commissions have been constituted by the government? It is 4. Okay. What is the status of the delimitation commission? Statutory body. And what are the functions that is performed by the delimitation commission? First is, the most important thing is to determine the total number of seats, then to redraw the boundaries. In fact, they have to redraw the boundaries before every general election as per the population. And which population is used? 2001 population. And they shall also reserve the seats for the scheduled caste and scheduled tribe, depending again on the basis of population. Which population? 2001 census. In fact, they have to keep rotating these reserved constituencies. It is not that the same constituency will always be reserved. So therefore, all the people are given equal opportunities. Okay. Consider the following statement. Statement 1. The departmentally related standing committee has representation from both Lok Sabha and the Rajya Sabha. Is it true? Yes. The DRSEs have got representation from both Lok Sabha and Rajya Sabha. Are the members of DRSEs elected or nominated? Are they nominated? Sure. All the members of the DRSEs are only nominated. The election is only for the financial committees that you have seen. So for these committees it is nominated. And 21 members from Lok Sabha, 10 members from Rajya Sabha. How many committees are there in Lok Sabha? 16. And how many committees in Rajya Sabha? 8 committees. And who will appoint the chairperson of the respective committees? The presiding officers of the respective houses. Okay. So that is something. The estimates committee has representation only from the Lok Sabha. Is it true? Yes. They have a representation only from the Lok Sabha. How many members from Lok Sabha? So they have got 30 members. So this is true. So in this case only is right. The general purpose committee has a specific function to perform as per the rules of the house. Is it true? If it has a specific function to perform, then it is not called as a general purpose committee. The general purpose committee has no specific function to perform. Suppose if there is no specific committee for a particular purpose, and then all those functions are taken up by the general purpose committee. So that is basically the role of the general purpose committee. So it does not have any specific function to perform. It will take up all the functions which is not belonging to a specific committee in the parliament. Okay. So that is why this committee is very important, and this committee is headed by the speaker himself in the Lok Sabha. So how many of the statements given above are incorrect? No, it is asking for incorrect. Which is incorrect? Only one statement, yes. Any doubt? Clear? Okay, come to the next question. Consider the following statements. Statement 1. The Joint Parliamentary Committee is a standing committee of the Parliament. JPC is again very important. There is lot of small news articles that I have come across with regard to the Joint Parliamentary Committee. So there may be a question on the Joint Parliamentary Committee also. The Joint Parliamentary Committee is a standing committee of the Parliament comprising of members of both the houses constituted under the direction of Supreme Court of India. Is it true? Why the Supreme Court will come? It is the role of the Parliament. There is no role of the Supreme Court in establishing a committee in the Parliament. So Joint Parliamentary Committee is usually established by the Speaker and the Chairman of Rajya Sabha. So they will consult, and according to their opinion they will constitute a Joint Parliamentary Committee. That means one thing that is sure of Joint Parliamentary Committee is it will have members from both the houses, and different Joint Parliamentary Committee established at different point of time will have different members. So there is no fixed members. So then and there when they decide, they will decide as to what is the number of members to be part of the Joint Parliamentary Committee. So therefore, an important understanding you should have is a Joint Parliamentary Committee is not a standing committee, it is an ad hoc committee. So as and when the need arises, they will establish what is called as a Joint Parliamentary Committee. Now for what purpose do you think a Joint Parliamentary Committee is established? Usually to scrutinize some controversial bills. So presently I think the Waqf bill which is pending in front of the Joint Parliamentary Committee, and not necessarily only to scrutinize the bills. Sometimes if the opposition say that there is a major corruption allegation against the government, to probe that also they can establish what is called as a Joint Parliamentary Committee. But however, not necessarily whenever the opposition asks for a joint parliamentary committee, the government may go for a joint parliamentary committee. It is a prerogative of the government, because both the presiding officers have to decide about it, and from which party the presiding officer is there, from the ruling party, the speaker, and anyways the vice president is also elected by the government, so majorly, so they have control over both the houses. So therefore, if the government accepts, then they can go and establish what is called as a joint parliamentary committee. Do you have any instance of joint parliamentary committee established to probe the corruption against the government? Yes, in 1980s, to probe the Bagh scandal, a joint parliamentary committee was established, and at that point of time the BJP was a major opposition party, the Congress was the ruling party, and the BJP demanded, the Congress accepted. So in 2016-17 the Congress said that we wanted to probe against what is the Rafale deal, and earlier we accepted for a joint parliamentary committee on BOFAs, but the BJP government did not accept for it, so there was no JPC. But yes, this is how the JPC may get established. The Joint Parliamentary Committee is a standing committee of the Parliament comprising of members of both the houses, constituted under the direction of the Supreme Court. No, but constituted as per the consultation between the presiding officers of both the houses. So therefore, that particular statement would be wrong. So statement 1 is wrong. So remember that. Come to statement 2. The Public Accounts Committee has representation only from the Lok Sabha, ensures financial accountability of the executives to the legislature. Well, the objective is correct, but not the membership, because it has got representation from both the houses. So this is also wrong. So what is the answer? Which of the statements given above is incorrect? Both 1 and 2. Consider the following statements regarding the ordinance making power of the president. So what is with regard to the ordinance making power of the president? 1. The ordinance can be made at the discretion of the president. Is it true? The ordinance cannot be made, but it is based strictly on the aid and advice of the Council of Ministers. Ordinance requires approval of the Parliament within 6 weeks of the reassembly. Is it true? Yes, both the houses of the Parliament has to approve within 6 weeks after its reassembly. Okay, so this is true. Ordinance can be withdrawn by the president anytime. Yes, at any time the president can withdraw it, but based on the aid and advice of the Council of Ministers. So this is true. So how many of the statements are incorrect? 1 only. Okay, so try to give me an answer for this question. What is the answer? Because I have already discussed a similar question. The President of India has a power to exercise which of the following veto powers in case of a constitutional amendment bill? What type of veto he can exercise? As per the constitution, after the 24th Constitutional Amendment Act, the President is bound to give the assent whenever a bill is passed. But can he sit on top of a constitutional amendment bill? If he is sitting on top of it without giving the assent, the government cannot do anything except for impeaching the president. But however, that is not explicitly given in the constitution. What is explicitly given in the constitution? The thing that is explicitly given in the constitution is that he has to give the assent. So therefore, he cannot exercise what? Therefore, as per the constitution, he shall not exercise absolute veto. He shall not exercise suspensive veto. This is also not given explicitly in the constitution. What is explicitly said in the constitution is only to give the assent. Okay, so therefore, the answer is what? It is none. What will follow if a money bill is substantially amended by the Rajya Sabha? What will follow? It's a very simple question. The Lok Sabha may still proceed with the bill accepting or not accepting the recommendation of the Rajya Sabha. So therefore, who is the final authority when it comes to the money bill? It is only the Lok Sabha. That is why it is very important that the speaker should not abuse or misuse his particular power. Once a speaker certifies a bill as a money bill, then the Rajya Sabha is deprived of its powers. So sometimes the government may not need to have a majority in the Rajya Sabha. All that they have to do is they have to certify a bill as a money bill. And once they certify a bill as a money bill, they can silence what is called as the Rajya Sabha. but this may not happen in case of a constitutional amendment bill, but in all other bills they can do this, because in a constitutional amendment bill it has to be separately passed in both houses of the parliament by special majority. Is the decision of the speaker subject to judicial review with regard to certifying a bill as a money bill? Yes, already we have a precedent. I think the 2017 finance bill which was certified as a money bill is still with regard to the judiciary. A judgment was given, but I think now it has been taken by a larger bench, which is still there in the judiciary. So therefore, is it subject to judicial review? The answer is yes. Okay. Again on the grounds of malified intention, because if there was a malified intention behind certifying a bill as a money bill, it can be judicially reviewed. With reference to the union government, consider the following statements. Statement 1, the Department of Revenue is responsible for the preparation of budget. Is it Department of Revenue? No, Department of Economic Affairs. No amount of money can be withdrawn from the consolidated fund except the authorization of the parliament. So this is true. All the disbursement made, so this is I think repeated this question. Okay, so previous year question has got repeated. All the disbursement made from the public accounts also require the authorization of the parliament. No. So what is the answer? Okay, come to the next question. Consider the following: salary of President of India, pension of judges of Supreme Court and High Court, debt charges of Government of India. Of all the things that is given, which are all charged upon the Consolidated Fund of India. What about the salary of the President? Yes. What about the pensions of judges of Supreme Court? What about the pensions of judges of High Court? Is it charged on the Consolidated Fund of India? What about the salaries of the judges of the High Court? It is charged on the Consolidated Fund of the respective state. Be very clear. What about the debt charges of the Government of India? Yes, that is also charged on the Consolidated Fund of India. So can you give me an example of what is the debt charges of the government? Debt charges include the interest that the government has to pay, whatever borrowings that they have made, or sometimes whatever loans that they raise. So all these things will be part of the debt charges. So they are all charged upon the Consolidated Fund of India. So what is the answer? 3 only. Consider the following statements. The parliamentary privileges exercised and enjoyed by the members of the parliament are codified by an act of parliament presently. Is it codified? They are not yet codified. So presently, what are the sources of parliamentary privileges? The constitution and the conventional practices. And for the state legislature, what are the sources of parliamentary privileges? Same, constitutional provisions and the conventional practices. But in the future, is it possible for the parliament to make a law and codify it? The moment the parliament will make a law and codify the privileges, then the conventional practices cannot continue to be the privileges. So similarly, in the future, can the state legislature make a law and codify the parliamentary privileges for the members of the state legislature? Is it possible? See, as per the Constitution of India, the parliament can make a law and codify the parliamentary privileges for the members of the parliament. Now similarly, for each and every state, the state legislature can make a law and they can codify the privileges for the members of the state legislature. So the moment they will codify the parliamentary privileges, then the conventional practices cannot continue to be a privilege. So therefore, till this point of time, though there is a provision, either the parliament or none of the state legislature in our country has made a law in this particular regard. So this is definitely a wrong statement. The quorum in case of parliament constitutes not less than 1/10 of the total members of the house. Is it true? Yes. This is again a conventional practice. Nothing is there in the constitution in this regard. Okay. Okay, it is about the quorum. Sorry. So quorum is there in the constitution. So quorum is mentioned in the constitution, but the leader of the opposition, that is not mentioned with regard to what is the majority that they should have. That is not there in the constitution. So quorum is 1/10, that is explicitly given in the constitution. But can it be changed in the future without amending the constitution? Is it possible? See, it is mentioned in the constitution, so therefore is it possible to change the quorum without amending the constitution? Yes or no? How many of you think it is yes? So how it can be changed? by an act of parliament. The parliament is free to make a simple act of parliament and they can change it if they want. But however, it has not been done till this point of time. Okay. So it does not require a constitutional amendment to change this. The salaries and allowances of the members of the parliament are determined by an act of parliament. Is it true? Yes, their salaries and allowances are determined by an act of parliament. So what is the answer in this case? Okay, sorry, what is the answer? This is not true, this is true, this is true. So how many of the statements are incorrect? That is one only. Consider the following statements. Statement 1. A bill amending the constitution requires a prior recommendation of the President of India for its introduction in the House. Is it true? No. See, there are certain areas, even in PYQs it is getting repeated. When a constitutional amendment bill is presented to the President of India, it is obligatory for the President to give or his or her assent. Yes. Which constitutional amendment? 24th. So the idea is, the moment you attend this particular class, most of the things should be there in your mind. But the problem is that still there are 50 days to go for the examination. So if it is 1 week, probably you can retain most of the information, but still 50 days is a long time to go. In 50 days you can make wonders. In 50 days you can change whatever is already there, if you can use it, if you are confident, if you work towards it. So therefore 50 days is still a long time for you to work, plan and to achieve what you want to achieve. Okay. So why I am saying this, after attending the class you should again revise at a regular interval. Now it might appear that yes, you know most of the things, but after 10 days if you don't revise, most of the information might, there are few information you can retain. Maybe you will be able to do 50% of your efficiency if you don't revise, but if you revise you can do it up to 80 to 90%. Okay. A constitutional amendment bill must be passed by both the Lok Sabha and the Rajya Sabha by a special majority, and there is no provision of joint sitting. Is it true? Yes, there is no provision for the joint sitting. So therefore this is also true. So what is the answer here? It is 2, 1, 3 only. What are the options available in front of the Legislative Council when an ordinary bill is passed by the Assembly? What are the options available in front of the Council when the Assembly passes it? Can they reject the bill? Think about it. Can they reject the bill? Of course they can reject the bill. Do not have a misunderstanding. Now the basic misunderstanding that the students have is, we say that the Council does not have equal powers. Of course the Council does not have equal powers, but it does not mean that they cannot reject it. So constitutionally they have the power to reject it, but even if they reject it, there is a way that the bill can still become an act. But can the Council reject it? Yes, the Council can reject it. So what are the options that they can exercise? They can accept it, that is they can approve it, they can approve it, that they can accept it, they can pass it with amendments. Can they make amendments, send it back to the Assembly? Yes. But if they send it to the Assembly, if the Assembly does not accept it, then the bill is deemed to be passed. Okay, so that is the thing that you have to understand. So yes, they can make amendments and they can send it back. That is not an issue. So they can make amendments and they can send it. They can even reject the bill. They can reject the bill, they can approve it, or they can keep it pending for 3 months. But the thing that you have to understand is, so whenever, let me just take a moment here. So some students may not have a clarity here. Suppose if the bill is passed by the Legislative Assembly, sent to the Legislative Council. So what the Council can do is, the Council can accept it. If they accept it, no issues. Or what they can do is, they can reject it. Can they reject it? Yes, this option is given there in the Constitution. But the bill does not come to an end just because they are rejecting it. Or what they can do is, they can make amendments. But if they make the amendments, in this particular case, it cannot go to the governor for the assent. If they make an amendments, again they have to send it back to the Assembly. Okay, so when they send it back to the Assembly, if the Assembly accepts it, it's okay. If the Assembly does not accept it, then the Assembly will again send the bill back to the Council. Second time it will send the bill back to the Council. When the Assembly is sending the bill back to the Council for the second time, what is the time limit that the Assembly has got? Within 1 month they have to either accept it, or they can reject it also, or they can again suggest the amendments. They can still persist with their amendments. But whatever may be the case, After 1 month, it is deemed to be passed in the same manner as it is passed by the assembly. Or the last thing that they can do is, they don't take any action for 3 months. That means the bill is introduced in the council, but the bill has not moved forward. So in this case also, in any of these cases, whether they reject it or whether they make an amendment or it has 3 months have lapsed, in all these cases, the assembly will again send the bill back to the council. And what is the maximum time that is there for the council to act? If they accept it within 1 month, it is okay. But except for accepting, if they do any of the other 3 things, after 1 month, it is deemed to be passed in the same manner as it is passed by the assembly. So therefore, what is the maximum time for which the council can delay the passage of a bill once it is passed from assembly to council? 3 months in the first instance and 1 month in the second instance. So therefore, maximum 4 months. Okay, just try to keep this in your mind and just quickly come here. So can they reject the bill? Yes, they can reject the bill. Rejecting the bill means, it doesn't mean that the bill will come to an end, but they can reject the bill. If they reject the bill, assembly will again send the bill back to the council. So keep it pending for 3 months. Is it possible? Yes. Can they approve the bill? Yes. Can they pass it with amendments? Yes, this is also possible. So what is the answer here? All of the above. So many students, I have seen that they have an understanding that the council cannot reject the bill. No, it is explicitly given in the constitution that the council can reject the bill, but that does not mean that the bill comes to an end. If they reject the bill, again the assembly will send the bill back to the council. So what is the answer? Option D. Which of the following statement is true regarding the sessions in the parliament? The presiding officer has the power to prorogue the session of the parliament. Is it true? No. Who has the power to prorogue? It is only the president and not the presiding officer. What the presiding officer can do? So he can adjourn and he can adjourn sine die. Okay. The constitution prescribes the minimum number of sessions in a year. No. The only information that is given in the constitution is that there shall not be a lapse of more than 6 months between 2 consecutive sessions. The adjournment of a session can be done only by the President of India. The President of India will not do the adjournment. Who will do the adjournment? It is done by the, not the speaker, by the presiding officer. Don't assume it is only in the Lok Sabha. Okay. So it is a presiding officer. So it is not the president. So which of the statements given above are correct? What is correct? None of the above. So please give me the answer for this question. Which of the following majority is required for the election and the removal of the speaker and the deputy speaker? For election, what majority? For the removal? Sure. The only qualification for someone to get elected as a speaker or the deputy speaker, what is the qualification? There should be a member of that particular house, that is the Lok Sabha. So what is the answer here? It is option D. Okay, come to the next question. Consider the following statements regarding the disqualification of a member of a parliament. The member of a parliament is disqualified. So it is not or, is disqualified by the President of India in all cases. Is it true? Is it true in all cases? Yes, in most of the cases it is done by the President, but there are some exceptions also. What are the exceptions? That anti-defection law is an exception. So therefore, to say it in all the cases, it is an extreme statement. So please keep it in your mind. Always watch out for extreme statements. And 90% of the cases, extreme statements are wrong, but not in all the cases. So that is again very important. So you will have to take a call whether it is right or wrong. But if you are not sure, you can go for wrong. But in most of the cases, how UPSC do it? Whenever they use a word only, exclusively, in all the cases, these are all extreme statements. So please watch out for the extreme statements. If you even, why I am saying that you to practice lot of PYQs, from my experience, because I have done a lot of PYQs over a period of time, not only for polity, as a student I used to do for all the subjects, and even with the language I will be able to get 2-3 questions extra, because I am not knowing the answer, but I know the language of UPSC. So I make an educated guess in those areas, which helped me to sometimes get 2 to 3 questions. and thereby you will understand at the later stages every single question is going to be very important. You will have nightmares if you make a mistake on a simple question. So please try to avoid that. So based on experience, suddenly in the middle of the night you will wake up and start checking the key, and you look for whether any institute has given this answer as right. So whether it may be right or wrong, but you will try to make sure that yes, you have not done the mistake. So these things should not happen. So be very careful at the time of examination. Okay. And also, anybody has got an issue of marking in the OMR. So that is again very important. Okay. So how you do it in the OMR? Do not do it in one single go, because that can turn out to be disaster. So if you haven't that practice of going in one single go, wherever you have made a mistake, then you cannot undo itself. So therefore, do not go. Either you do it question by question, or you do it for 3 questions. For example, in UPSC, in every page there will be 3 to 4 questions. Whenever you solve that 4 questions, mark those 4 questions. That's the best way, because you will keep a tab whether you are making mistakes or not. It will remember see the questions also. But you will feel that okay, I'll solve all the questions and then I'll do. That is not a right approach. You can do it if you like it, but I won't suggest that. The best way to go for your OMR is, in every page I think UPSC will have 3 to 4 questions. Solve those 3 to 4 questions, mark those 3 to 4 questions. Then again solve the 3 to 4 questions, mark those 3 to 4 questions, because your errors will be localized. Even if you are making an error, still there is something that you can do about it. But in one go if you do, there is a possibility that you can commit mistakes. So that is not a right approach. Or you can do it question by question also. It is up to you. Okay. Okay. So the members of the parliament is disqualified by the President of India in all the cases. So that is wrong. No. In case of anti-defection law, the presiding officers must decide the disqualification petition within 3 months. Is it true? No. There is no time limit. A member of parliament can be disqualified for holding office of profit. Is it true? Can a member of parliament be disqualified for having office of profit? Is the office of profit defined in the constitution? So yes, of course, the member of parliament should not hold on to any office of profit. But has anyone thought of what is the reason as to why a member of parliament should not hold on to office of profit? Because that creates a conflict of interest. A legislator, a person who is part of a legislative body to occupy an executive post creates a conflict of interest, because as per the constitution, what is the primary function of a legislator? To hold the executives accountable. So if he himself turns out to be an executive, then who will make the executives accountable? So it creates a classic conflict of interest. So therefore, that is not allowed under the constitution, but there are exceptions, because India is a parliamentary democracy, because the executives ultimately has to come from the legislator, from the legislative body. So therefore, some exceptions are given to the ministers and other thing, but not every legislator can be part of what is called as an executive. So how many of the statements given above are correct? One is correct. A member of parliament can be disqualified for, okay, sorry, the member of parliament can be, so this is not the wrong one. So yes, they can be disqualified for holding office of profit. So member of parliament can be disqualified. So what is the answer here? One only. Consider the following statement. Statement 1. The duration of both the houses of the parliament is fixed under the constitution of India. Is it fixed? It is not fixed under the constitution. The duration of both the houses of the parliament is fixed under the constitution. The duration of both the houses is not fixed under the constitution. So what they are trying to assess, the duration of both houses of parliament is fixed under the constitution. Of course it is not, because anyways Rajya Sabha is a permanent house. So therefore there is no fixed duration, because the key word here is both the houses. If they say Lok Sabha, yes, there is a duration for that, 5 years, but again it is not fixed, because it can be dissolved earlier also. But definitely you can make this wrong, because the Rajya Sabha is a permanent house. Any person contesting the election to the Lok Sabha should be an elector from any constituency in that state where he or she is contesting the election. Is it true? It is not necessary that he or she should be an elector from that particular state. He or she can be an elector in any constituency in India. So how many constituencies are there in India presently? 540? 543, very good. Don't assume it to be 545. It is only 543 constituencies. Earlier 2 seats were for nomination from the Anglo-Indian community. It is only 543 constituencies. But however, the maximum number of constituencies given in the constitution is what? 550 constituencies. But however, presently only 543. 550 is maximum, but only 543 is presently allocated. Any person contesting election to the Lok Sabha need not be an elector from the state, but anywhere in India. So which of the statements given above are incorrect? Both 1 and 2. Come to the next question. Consider the following statements regarding the seats allocated to the Lok Sabha. The total number of seats allocated to the Lok Sabha from every state is presently based on 2001 census. Is it true? It is based on which census? 1971 census. Very good. It is based on 1971 census. I think only 10 more questions are there for the legislature. I will complete it and I will take any doubts if you have, okay, for the online students also. The Delimitation Commission, which entrusted with the above function, is a constitutional body. What type of body? It is a statutory body, not a constitutional body. There is no representation of union territories in case of Lok Sabha. Is it true? There is no representation. It is an extreme statement. There is no representation in case of the Lok Sabha, representation in case of union territories in case of Lok Sabha. In fact, all the union territories are represented in the Lok Sabha. At least 1 seat is given for every union territory in the Lok Sabha, but you can say that not all the union territories are represented in the Rajya Sabha. Only very few union territories are represented in the Rajya Sabha. What are the union territories that is represented in the Rajya Sabha? Delhi, Puducherry and Jammu and Kashmir. These are the only 3 union territories, okay. So to say no union territories are represented is wrong. So what is the answer here? Which of the following are incorrect? So it is 3 only. Which of the following Constitutional Amendment Act has done away with the nomination of the Anglo-Indians to the House of People? Which Constitutional Amendment Act? So let us try to see the last 7-8 amendments quickly. So let us see. What about the 99th Constitutional Amendment Act? Where the Supreme Court has struck down the NJSC. On what grounds it has struck down the NJSC? On the grounds that it is violating the basic structure, that is the independence of the judiciary. What about the 100th Constitutional Amendment Act? Exchange of enclaves between India and Bangladesh, because whenever India cedes a territory to a foreign country, it can be done only under Article 368 of the Constitution. 100th Constitutional Amendment Act. 101st Constitutional Amendment Act, GST reforms. They have inserted number of new articles, especially the article like 246A, 279A. So these articles has been inserted. What about 102nd Constitutional Amendment Act? They have given the constitutional status to the National Commission for Backward Classes. Inserted Article 338B and also 342A. So these articles has been inserted. Articles are not important, at least try to remember the constitutional amendment. 103rd Constitutional Amendment Act, they have given EWS reservation. Inserted Article 15 Clause 6 and Article 16 Clause 6. What about Article 104 of the 104th Constitutional Amendment Act? So they have done away with the Anglo-Indian nomination, while they have given extension to the representation to the scheduled caste and scheduled tribe, but the nomination to the Anglo-Indians has been done away with. 104th Constitutional Amendment Act. What about 105th Constitutional Amendment Act? They have restored by after the 102nd Constitutional Amendment Act, there was a confusion whether the states can have their own backward classes, whether they can determine the list of their backward classes in the respective state. So that was restored by the 105th Constitutional Amendment Act. Again, it is related to the states getting their power back to have their own backward classes when it comes to the other backward classes reservation. What about 106th Constitutional Amendment Act? The reservation of seats to women in the legislature, that is both in the Lok Sabha as well as in the not in the Rajya Sabha. In Rajya Sabha there is no reservation. In the Lok Sabha and the state legislature. Now today the women's have reservation in all the 3 categories of elections: local bodies, legislative assembly and also in the Lok Sabha. But yes, it will take some time to get implemented, but yes, that provision is already there in the constitution. Okay. So the latest amendments you should be aware of. So in this case, what is the answer? No, there is no reservation in the Legislative Council. There is no reservation in what is called as the Rajya Sabha, because the reservations are only given to the areas where they represent the people. The Legislative Council does not represent the people. The Rajya Sabha does not represent the people of our country. So therefore, there is no reservation in that particular case. So what is the answer here? 104th Constitutional Amendment. Consider the following. Statement 1, open ballot system, disqualification on the defection for cross voting, proportional representation. Which of the above are the feature of Rajya Sabha elections? Does the Rajya Sabha election is based on the system of proportional representation? Yes, it is based on the system of proportional representation. Who constitute the electors for the Rajya Sabha elections? The elected members of the legislative assemblies of the concerned state. Be very clear about it. So therefore, yes, proportional representation is definitely true. What about the system of election? Is it open ballot or secret ballot? It is partial open ballot. So therefore, you can call it as open ballot. Now, what is this partial open ballot system? Normally, open ballot means that everybody will know. But here there is a system of partial open ballot, which means every MLA who is voting in the elections, they have to disclose their vote to a particular person who is nominated by the party. The party will nominate a person, and to that person they have to show their vote, that they are voting to the right person. So therefore, yes, if they don't disclose their vote, then what will happen to their vote? That vote will be considered to be an invalid vote. It will not be counted. So therefore, open ballot is also right. But the important question is, does it would amount to disqualification on the grounds of defection if they are doing cross voting? Will it amount to disqualification on the grounds of defection? Because if the party is giving some directions, if they act contrary to the party directions, they are liable to be disqualified as per the anti-defection law. So here, if the party is giving a direction to vote to a particular candidate, but if an MLA is voting to a different candidate, although he is disclosing, so therefore they are knowing it also, is he liable to be disqualified under the anti-defection law? Yes or no? How many of you think no? Please raise your hand. How many of you think yes? They are liable to be disqualified. They are not liable to be disqualified under the anti-defection law. Now, why? The Supreme Court has clearly said why they are not liable to be disqualified, because the anti-defection law will apply only in case of a legislative proceedings. That means, as a part of a legislative body, if you are performing any of your duties and responsibilities, and then if there is a cross voting, they are liable to be disqualified. But the question is whether voting in the election to Rajya Sabha is a part of a legislative proceeding. The Supreme Court said no, it is not a legislative proceedings. So therefore, you should have an understanding of what is a legislative proceeding. A legislative proceeding means introduction of bills, having some debates, some motions, voting in those motions. These are all legislative proceedings. These are all job of the legislature. But this is just an election where you will have the right to vote. This is not part of a legislative proceeding. So therefore, here the anti-defection law will not apply. Although the party is free to take a disciplinary action, the party can expel them from the party, but that does not mean that it will be disqualified as a member of parliament or a member of state legislature. That is not possible. Is that clear to all of you? So here the anti-defection law does not apply. So disqualification on the grounds of defection for cross voting is not the case. So which of the above are the feature of Rajya Sabha elections in India? What is the answer? It is 1 and 3 only. Very, very important. So these are all the areas you should have remember this, okay? Because if you don't remember, generally what will come to your mind is the anti-defection law, okay? So because it is not considered to be what is called as a legislative proceeding. Come to the next question. With reference to the parliament under the constitution, consider the following statements. Statement 1, the parliament comprises of both elected and nominated members. Is it true? Yes, it consists of, especially in the Rajya Sabha, there is a nominated member. But in general, what the parliament comprises of? The members, it consists of Lok Sabha, Rajya Sabha and the President of India. So the President of India is also an integral part of the parliament. All the members of the Council of States are elected indirectly, and they can be elected only in the form of, only from the state where they are a resident. So when you say that all the members are elected indirectly, itself is wrong, because there are nominated members also. And can they be elected only from a state where they are a resident? Before 1996 this was the case, but subsequently the Representation of People Act has been amended. Today they can be resident in anywhere in India to get elected in the Rajya Sabha, not necessarily from the same state. So this is anyways wrong. Which of the statements given above are correct? One only. Consider the following statements regarding the privilege motion of the Parliament. So privilege motion is again very important. Now when this privilege motion is introduced, the privilege motion is introduced usually when any member of Parliament breaches the parliamentary privilege, or when he try to bring disrepute to the other members of the Parliament. So then they can introduce what is called as privilege motion. So recently the Congress was trying to introduce this privilege motion against Mr. Amit Shah, but the speaker did not allow for it, but they are trying to introduce this privilege motion. So whenever a privilege motion is introduced, they should bring in a notice that they wanted to introduce a privilege motion against a particular member. And then if the speaker or the presiding officer, because it can be introduced in both the houses, if the presiding officer gives a permission, then the notice will be admitted. And then once a notice is admitted, then the matter will be taken up by the privilege committee, because the committee has to study this particular matter. So therefore, to study this particular matter, both the Lok Sabha and Rajya Sabha has got their respective privilege committees. In the Lok Sabha, it has got 15 members. In the Rajya Sabha, it has got 10 members. Now all these members are nominated. There is no election to this privilege committee. They are nominated, and the presiding officer is usually, the chairperson is usually nominated by the presiding officer. Okay. And then they will submit the report back to the House, and based on the report that is submitted to the House may collectively take some action against the member if they found that the member has breached the parliamentary privilege. Okay. So with that, please come to the question. It can be moved only in the Rajya Sabha with the permission of the presiding officer. This is part of your current affairs. So can it be moved only in the Rajya Sabha? It can be moved both in the Lok Sabha as well as in the Rajya Sabha. Usually if the person is from Lok Sabha, it will be moved in Lok Sabha. If he is from Rajya Sabha, it will be moved in Rajya Sabha. So this is wrong. The privilege committee in the Rajya Sabha consists of 10 members. Is it true? Yes. In Lok Sabha, how many members? 15 members. So this is true. Which of the statements given above are incorrect? What is incorrect? One only. Please come to the next question. Which one of the following is true regarding the joint parliamentary committee? It is an ad hoc committee. Is it an ad hoc committee? Of course it is an ad hoc committee. It comprises of members of both houses of the parliament. Is it true? Yes. The recommendations of the committee are binding upon the parliament. Is it true? Not only that of the joint parliamentary committee, the recommendation of any of the parliamentary committees is not binding upon the government. They are merely a recommendatory body. So what is the answer? 1 and 2 only. Who is authority to disqualify the members of the state legislative assembly on the grounds of defection? On the grounds of defection, who is authority? So among the given thing, who is the right? What is the right answer? So you will have to always see based on the option. So the option is, it is a speaker. Consider the following statements regarding the removal of chairman Rajya Sabha. Again very important, because there is a notice that the opposition was trying to introduce with regard to the removal of the Rajya Sabha chairman, that is none other than the vice president. While a motion to remove the chairman of Rajya Sabha is pending in the House, he or she cannot preside over the House. Is it true? Once a notice is admitted, then the chairman cannot preside over the House. So the deputy chairman will preside. So therefore this particular statement is correct. What is the notice time that has to be given? 14 days of notice. The removal motion has to be passed with effective majority in both the houses of the parliament. Is it true? So it has to be passed. Does it require to be passed in both the houses? Yes, but in the Rajya Sabha, what is the majority? And in the Lok Sabha, simple majority. In which house it can be introduced? Only in the Rajya Sabha. So therefore to say that it requires effective majority in both the houses is wrong. So which of the statements given above are incorrect? What is incorrect? The question is asking for incorrect. So what is the answer? 2 only. Come to the next thing. The Delimitation Commission of India is what? Is a statutory body. So we already discussed this. Who shall determine the service conditions of the secretarial staff of both houses of the parliament? In fact, try to understand that as per the Constitution of India, both houses can have their own secretariat staff. So they can make recruitment and all those things. And who is heading the secretarial staff? The Secretary General Lok Sabha for the Lok Sabha and the Secretary General Rajya Sabha for the Rajya Sabha. But as per the Constitution, who shall determine their service conditions? What is the answer? The presiding officers, the President of India. It is the Parliament of India which has got the power. The Parliament may by a law determine their service conditions. Okay. So very important. How many of you thought it would be the Parliament? How many of you would have actually gone for the Parliament if it is an UPSC exam? How many of you would have gone for the President? How many of you would have gone for the presiding officer? So these are all areas which looks very simple, but there is a possibility of making mistakes, and these are all the areas you cannot apply logic also, because everything looks like right. So therefore, unless and until you read it, you will not be able to do it. Okay. If luck is in your favor, yes, sometimes you can get it right. But as I always say, you cannot go to the examination only on the basis of luck. That is a very bad strategy. If you will think that the luck will favor you. Of course, luck will favor you if you have worked hard for it. If not in 1 year, 1 year it will be in your favor. But the thing is, will you be able to persist till that point of time? That's another question. So therefore, your strategy should not be on the basis of luck. Your strategy should be on the basis of your own hard work and your own planning, and of course, to some element your smart work also. Only a little bit, not much in UPSC examination. Okay. Who shall determine the salaries and allowances of members of the Parliament? The Parliament itself. These are the only categories of people who can determine their own salary and allowances. Okay, so this is in case of Parliament. Okay, all right. Very quickly, any questions? I wanted to cover another at least 25, 30 or whatever is possible. The next part that you are going is Judiciary. But see, as of now, whatever we have completed, 8 to 10 questions, I am sure that you will be able to solve it. But provided you also revise it again at least 1 or 2 times, if not more times, at least a couple of times you can revise these questions along with whatever material that you have had for revision also. I am sure that here you can get 90% of the questions right. Okay, there is one question the student is asking. Question number 217. Can anyone give me the copy? Just I will see what is 217. Okay, so please listen. While all the money bills are financial bills, but not all financial bills are money bills. That is quite clear. So that particular statement is true. While the money bills can be introduced in the Lok Sabha, that is true, part of the statement. While the money bills can be introduced in the Lok Sabha with a prior recommendation of the President, the same is not true in case of the financial bills. The same is not true in case of the financial bills. The same is not true in case of the financial bill means that it is saying that not all the financial bills requires a prior recommendation of the President. So therefore, that statement should be true. So did I make it wrong? Okay, so I think there is some element of lapse in the concentration. So please make a change in question number 217. I think that is the reason I think the student have asked. So it is saying that the same is not true in case of the financial bill means it is not true because the financial bill type 2 does not require this. So if all the financial bill requires this, then it is wrong. So anybody who has a doubt, please ask me. Again, I am repeating it again. So please anyone give me the copy. Okay, look into the statement number 2 very carefully. While all the money bills can be introduced only in the Lok Sabha, is it clear? It can be introduced only in the Lok Sabha with a prior recommendation of the President. The same condition is not required for the finance bills. That means the same condition is not required for all the finance bills. So if it is for both the finance bill type 1 and type 2, if the same conditions are required, then this particular statement is wrong. But here it is saying it is not true in case of finance bill, because in case of financial bill type 1 it is true, but for not for the financial bill type 2. So partially it is right, but partially it is wrong. So therefore it is considered to be a correct statement in this case, because the question is not true. Okay. So please make a correction there. If you have any questions, you can ask me after the class also, but the second statement is right because it is given not true. So therefore, what would be the answer for that question? Both 1 and 2. Option C is the answer. Okay, shall I move to the next part? Any other questions? Okay, so can anyone tell me what is quorum? Quorum means is the minimum number of members who should be present in the house to carry out the proceedings. So without the minimum number of members, the presiding officer cannot carry out the proceedings, and that as per the constitution is not less than 1/10 of the members present in the house of the total membership of the house. Alright, so I think there is no other question from the online students. Any question? Yes, very quickly. Decisions are cabinet binding or not binding on whom? On the government. The government itself is a cabinet committee only. So therefore, to say that their decision is not binding is not an appropriate thing. Who heads all the cabinet committees? The Prime Minister himself heads all the cabinet committees. So therefore, their decision the government is likely to implement. Alright, any other questions? Yes. Not the previous Lok Sabha. The previous Lok Sabha is over. It may be joined by the new Lok Sabha, but it is very unlikely to happen. Once a joint sitting is convened and if the Lok Sabha dissolved, you never know, because again whatever will happen based on the aid and advice of the Council of Ministers. So therefore, the same Council of Ministers will come or not, the same government will come or not. So normally that bill will automatically will not become an act. It is very unlikely, but the bill may not lapse as such. If the government wanted to continue, they can continue, but it is very unlikely it will become an act. Okay, but definitely not the previous Lok Sabha. It is the new Lok Sabha. Alright, shall I move to the next part? Okay, so please come to the next part, which is about the judiciary. So from now on, whatever topic that I am taking up, possibility is one question. One question for all the small topics. Okay, so judiciary also one, maybe two questions. So randomly UPSC can ask. So whatever we are going to see from here on is for 5 to 7 questions. 8 to 10 questions you already covered. Okay, so come quickly to the judiciary part. Consider the following statements. Consider the following statements. The Supreme Court of India tenders advice to the President of India on matters of law or fact, the conditions on its own initiative. Is it true? First of all, tell me under which article the Supreme Court will tender the advice? Article 143 of the Constitution, and who can seek this advice? The President of India can seek this advice. Very good. So under Article 143 of the Constitution, the Supreme Court will not give the advice on its own, but only when the President asks for the advice on a question of law or a question of fact or the interpretation of the Constitution. So the President has to initiate this. But however, the President can ask two types of advice: an advice which is related to post-constitutional matters and an advice related to what is called as pre-constitutional matters. So, but however, in both the cases, the opinion that is given by the Supreme Court is not binding upon the government. But however, if it is a pre-constitutional matter, the Supreme Court is bound to give the opinion. But the Supreme Court is not bound to give the opinion when it is a post-constitutional matter. But however, in both the cases, try to understand, in both the cases, it is not binding upon the President or the government. But in one case, when they are bound to give the opinion, in case of what is called as a pre-constitutional matter, that is any dispute that has arisen before the constitution came into force, or any agreement that is entered upon before the constitution itself, which is still in force. So now come to this particular question: on its own, is it true? No. If he seeks such an advice, yes. Only if the matters related to the fundamental rights of the citizens, not necessarily, no. So which of the statements given above are correct? It should be 2 only. That is option B, which is correct. Is it mandatory for the Supreme Court to give the opinion? When it becomes mandatory for the Supreme Court to give the opinion? If it is related to a pre-constitutional issue. But if it is a post-constitutional issue, it is not mandatory. But in both the cases, whatever is opinion is not binding upon the president, because in both the cases it is not considered to be a judgment of the court. It is not considered to be a decree or a judgment of the court, because any judgment of the Supreme Court is binding. But this is not a judgment, this is merely an advice or an opinion which is given by the Supreme Court. So therefore, it is not also precedent to the other courts in our country. There is one provision in the constitution which talks about any judgment or an award which is passed by the Supreme Court is binding upon all other courts. Under which article it is binding upon all other courts? Article 141 of the constitution. Very good. But however, whatever opinion which is given by the Supreme Court under article 143 is not considered to be a judgment or a decree. It is not setting any precedent for the other courts. It is strictly related to only to that particular matter. Okay, and that too is not binding upon the president. Okay, consider the following statements. The Central Administrative Tribunal (CAT) was set up during the Prime Ministership of Lal Bahadur Shastri. Is it true? When was the Central Administrative Tribunal was established? In 1985. In 1985, it was Mr. Rajiv Gandhi was the Prime Minister of India, because the Central Administrative Tribunal was established based on the Administrative Tribunal Act 1985, and the Administrative Tribunal Act 1985, which led for the establishment of Central Administrative Tribunal by the center and the State Administrative Tribunal by the states, and based on which article in the constitution they are established? Article 323A of the constitution. So therefore, the Central Administrative Tribunal, is it a constitutional body? Is it a constitutional body? Constitutional, a statutory, which type of body is it? If you look into article 323A of the constitution, article 323A of the constitution is saying that the parliament shall have the power to make a law, and by that law they can allow for establishment of what is called as administrative tribunal. So therefore, the administrative tribunal in our country is only a statutory body. So under article 323A, only one type of tribunal can be established by the law that is made by the parliament, and under article 323A, only the parliament can make law, and by that law they can establish only one type of tribunal. And what is a tribunal? Administrative tribunal. But the administrative tribunal is a statutory body. And there is also another article, that is article 323B. Under article 323B, both the parliament and the state legislature can make laws, and they can allow for establishment of any other tribunal apart from administrative tribunal. So for example, we have taxation tribunals, we have green tribunals, we have electricity tribunals, we have rent tribunals. All these tribunals are established under which article? Not directly under article 323B, but 323B is giving the power to the parliament and the state legislature. Is that clear to all of you? So only one type of tribunal under article 323A, other type of tribunals under article 323B. But whatever tribunal that can be established in our country, they are all considered to be statutory bodies. They are not constitutional bodies. Clear? So then the member of CAT are drawn from both judicial and administrative streams. Is it true? This is not only with regard to the administrative tribunal. The general principle that is followed by law in our country is that they will have both judicial experts as well as technical experts related to that particular matter. So that is also true. So the member of the CAT are drawn from both judicial as well as administrative matters. So this is true, this is wrong, because this is under the leadership of Mr. Rajiv Gandhi. So which of the statements given above are correct? Two only, option B. Consider the following statements. Justice V.R. Krishna Iyer was the Chief Justice of India. This is again a factual statement. Sometimes they can randomly pick. UPSC has asked this particular question. Now why? Because they wanted to ask question on public interest litigation. Justice V.R. Krishna Iyer was considered to be one of the pioneer of what is called as a public interest litigation. So he in fact entertained a number of cases as a part of what is called as public interest litigation. But he is one of the most respected judges in our country, Supreme Court judge, but he was never the Chief Justice of India. So what is the answer here? So Justice V.R. Krishna Iyer was a Chief Justice of India. No, that is wrong. Justice V.R. Krishna Iyer is considered to be one of the progenitors, pioneers of public interest litigation in the Indian judicial system. This is true. So which of the statements given above are correct? Two only. Okay, let me see how many of you are able to answer this question. How many high courts in India have jurisdiction over more than one state? excluding the union territories. Don't take the union territories, only for the states. 3, 2, 4. I want the states also, not just the answer. Tamil Nadu. Tamil Nadu, Madras High Court does not have over Andaman. Tamil Nadu High Court has over Puducherry. But anyways, you don't have to take into account the union territories. I have clearly mentioned it here. How many high courts in India have jurisdiction over more than one state? Only the state. Union territories not to be included. 2 or 3? 3? Yes, what are the 3? Can you recollect? Bombay High Court, which has jurisdiction over Goa also, state of Goa, yes, 1. Assam High Court. Assam High Court has got jurisdiction over, I think, the state of Nagaland, Arunachal Pradesh and Mizoram. Okay, yes, so Assam Guwahati High Court, true, 2. Very good. Punjab and Haryana High Court. So therefore, when it comes to the state, it is only 3. So what is the answer here? Only 3. Very good. So how many of you got this answer? Only 3. But don't stop it here. Also see as to how many high courts having jurisdiction over the union territories as well. So they can ask that also. Can you quickly answer this particular question? So which high court is having jurisdiction over the union territory of Puducherry? It is the Madras High Court. Which High Court is having jurisdiction over Andaman and Nicobar Islands? It is Kolkata High Court. Which High Court is having jurisdiction over Lakshadweep? Kerala High Court. Very good. Which union territory is having jurisdiction over Dadra and Nagar Haveli and Daman and Diu? It is Bombay High Court. And of course, it is a Punjab and Haryana High Court, which is also having jurisdiction over Chandigarh. And there are few union territories, they have a High Court of their own. There are 2 union territories which has got a High Court of own. One is National Capital Territory of Delhi, having a High Court of its own. Jammu and Kashmir has a High Court of its own. If any union territory is to have a High Court of its own, so who has authority to allow for a allow a union territory to have a High Court of its own? The Parliament by a way of a law. It is a Parliament that can create a High Court of its own. Okay. So come to the next question. Consider the following statements. The mode of removal of a judge of a High Court in India is same as that of the removal of the judges of the Supreme Court. Is it true? In fact, there is no change. Article 124 talks about the removal of the judges of the Supreme Court, and Article 217 talks about the removal of the judges of the High Court. But if you read Article 217, it says as it is for the judges of the Supreme Court. So what is the ground on which the judges of the Supreme Court and High Court can be removed? Either on the grounds of misbehavior or incapacity. Again, the removal part becomes very important. Removal and transfer, this here I feel is very important, because recently there was a allegation against a Delhi High Court judge who has been transferred to Uttar Pradesh, and there is also an internal enquiry that is going on. So therefore, all these things can be very relevant for your examination. So what is the ground on which they can be removed? It is either on the grounds of misbehavior or incapacity. Is the term misbehavior incapacity defined in the constitution? No. So to prove that, it has to be done through an enquiry process. And how the enquiry has to happen? It is based on the Judges Enquiry Act. And it also provides for a procedure as to how this enquiry has to be happened. But however, what the constitution says, after this enquiry, if at all a judge is to be removed, a removal motion has to be introduced, and it has to be passed with what majority in both houses of the parliament? Special majority. And what is a special majority? Not less than 2/3 of the members present and voting, and absolute majority as well. And it has to be passed with special majority in both the houses in the same session. And then subsequently he can be removed by the President of India. So therefore, who is the removal authority for the judges of the Supreme Court and High Court? President or the Parliament? There should be no doubt in this regard. It is the President who is the removal authority, not the Parliament. Just because the Parliament has passed a motion by special majority, the judges cannot be removed unless and until it is approved by the President of India. But the President cannot do so unless and until it is passed by both houses of the Parliament. But ultimately, who is the removal authority? It is the President who can remove them. Okay, so with that, you please come to the information question. the mode of removal of the judge of High Court in India is same as the removal of a judge of a Supreme Court. Is it true? Of course it is true, no change. Come to the next part of the question, that after the retirement of office, a permanent judge of High Court cannot plead in any of the court or before any authority. So some of the students asking, does it not amount to violation of his fundamental right? It is not about when his right is violated, he can file a case. Basically, when you say that he cannot plead in any court, he cannot practice as a lawyer subsequent to that, because he is also from a legal profession. Can he practice himself as an advocate in any of the court? So there is no complete ban for a judge of High Court. A judge of High Court can practice as an advocate in the Supreme Court or in any of the other High Courts from which he has not retired, but not in the same High Court where he has retired. So therefore, see the answer for this particular question. After retirement from the office, a permanent judge of High Court cannot plead or act in any court before any authority in India is an absolute statement. That is wrong. So this is applicable for the judges of the Supreme Court. A Supreme Court judge cannot plead anywhere within the territory of India, but a High Court judge can plead. He can plead in the Supreme Court or in any of the other High Courts. So this is wrong. So which of the statements given above are correct? It is one only. So these are all very random questions. So sometimes they can ask questions from the district. This also, this is in fact a previous year question. So that's why I picked it. So the judges, the highest criminal court of a district is the court of district and session judge. Is it true? See, he is in fact called as the highest court in the district is called as a court of district and sessions judge. Now why? Because the same person, when he is hearing the civil case, he is considered to be what is called as a district judge, and the same judge when he is hearing a what is called as a criminal case, he is called as a session judge. So therefore this particular statement is right only. Okay. The court is the same, it only depends upon the type of case he is hearing. The district judge are appointed by the governor in consultation with the High Court. Is it true? Yes, the district judge are appointed by the governor in consultation with the High Court, but the High Court judges are appointed based on the recommendation of the collegium by the president. When the session judge awards a death sentence, it must be confirmed by the High Court before it is carried out. This is true as per the criminal procedure code in our country. Whenever a death punishment is given by a sessions judge, automatically the matter will be reviewed by the High Court. Whether the individual wants it or he does not want it, automatically the matter will be reviewed by the High Court, just to make sure that there is no error in the lower court. So once it is confirmed by the High Court, then only it can be executed. Okay. But however, this is not there in the constitution, it is only as per the criminal procedure code, which has been renamed right now. Whatever is the name of the law, as per the law, it is the case. Which of the statements given above are correct? What is the answer? All the statements 1, 2 and 3. Under which article of the Indian Constitution did the President make a reference to the Supreme Court to seek the court's opinion on the constitutional validity of Elections Commission decision on differing? So this is not important. The only thing is, under which article of the Constitution did the President can make a reference to the Supreme Court? Which article? Article 143. Just now we have seen. So can the President make a reference on a question of fact? Not just on a question of law. On a question of fact also he can make a reference, but in any case it is not mandatory except if it is a pre-constitutional matter, but in any case it is not binding upon the President of India. Come to the next question. The salaries, allowances of the judges of the High Court. The salary allowances of the judges of the High Court are charged upon what? They are all salary allowances only, it is not the pension. So therefore it is charged where? It is charged on the consolidated fund of that particular state. The concept of public interest litigation originated where? The concept of public interest litigation originated not in United Kingdom, in United States of America. Because you cannot say United Kingdom, because United Kingdom does not have a written constitution in the first place. So the concept of public interest litigation has originated where? In United States of America. If you see two judiciaries which are more or less similar, it is only the Constitution of India and the Constitution of United States of America. They almost exercise similar judicial review. but there is a vast amount of difference between the judicial review powers of India and that of United Kingdom. So therefore, they work on an entirely different line, which is again a very important topic. In fact, the same question, this is a very simple prelims question, but it was asked in UPSC mains examination also. How is the power of judiciary, or to what extent the judiciary in India converge and diverge from that of the judiciary of United Kingdom? The basic element of divergence is because of the power of judicial review. There is one more question I will discuss when I come to that particular question. But anyways, what is the answer here? It is the United States of America. The power of the Supreme Court of India to decide the disputes between the center and the states, very important area. What is the jurisdiction? Original jurisdiction. So can you please tell me what are the cases that falls under the original jurisdiction? Now please tell me yes or no. Any dispute between the center versus state? Any dispute between the center and the union territories? No or yes? Sure? Any dispute between the center and the union territory is not a federal dispute, because union territory is part of the union government, the central government. So therefore, it is not a federal dispute. Any dispute between a union territory and a state? Yes, yes, because union territory is part of the center and state is a state. So therefore, it is a federal dispute. Any dispute between two or more states? Any dispute between two or more states with regard to interstate river water disputes? It is a federal dispute, but does not fall under the original jurisdiction, because any interstate river water disputes can be challenged only in front of such an authority as determined by the law made by the Parliament. So therefore, the interstate river water disputes can go only in front of a tribunal which is already established for that particular purpose. But if a tribunal passes an order but still there is no implementation, can any affected state still go to the Supreme Court? Yes, they can go to the Supreme Court, but not under the original jurisdiction, but as a special leave petition under Article 136. So please be very clear. Original jurisdiction means what? Where there is a federal dispute. Okay, so that is what is original jurisdiction. Under which article this original jurisdiction is given to the Supreme Court? Very good. Article 131 of the Constitution. This is just an extra information. Okay, come to question number 28. When the Chief Justice of a High Court acts in an administrative capacity, this is very important. When a Chief Justice of a High Court acts in an administrative capacity, will he fall within the definition of state? So if he falls within the definition of state, then he is subject to what? Then he is subject to the writ jurisdiction of any other judge in the High Court. So is that possible? Yes, because he falls within the definition of state. So therefore, his action should not be violative of the fundamental rights. And if it violates the fundamental rights of anybody else, they can move an application to any of the other judges and they can pass a writ against the Chief Justice of the High Court. So this is definitely true. So the answer is option A. Which one of the following comes under the jurisdiction of both the High Courts and the Supreme Court? Which will fall? Dispute between center and state, no. Dispute between state interstate, that is between two states. Protection of the fundamental rights, yes. Article 32 gives a power to the Supreme Court. Article 226 gives a power to the High Court. So therefore, the answer is option C. Come to the next question. Which of the following is true with regard to the power of the Supreme Court under Article 142 of the Constitution? So you should be very clear about Article 141, 42, 43, because you should not get confused. So can anyone tell me what is Article 141, 42 and 43? What is Article 141? The Supreme Court judgment is binding upon all the courts in India. Article 143, the Supreme Court is seeking the advice of the President, the President is seeking the advice of the Supreme Court. What is Article 142? Article 142 is talking nothing will prevent the Supreme Court in passing any kind of order or judgment in ensuring complete justice in a particular matter. That means nothing in the ordinary law will prevent the Supreme Court of India in passing any orders in order to ensure what is called as complete justice. In fact, I have given one example to the students where the Supreme Court has allowed for the medical termination of pregnancy of a rape victim after 24 weeks. Because as per the law in our country, if somebody has to terminate the pregnancy, till what point of time they can terminate the pregnancy? Only normally up to 20 weeks, in certain exceptional cases it can go up to 24 weeks, but not beyond 24 weeks. But in this case, the rape victim, she was not aware that she was pregnant, and she was aware only the time was already over. Then still she moved an application to the Supreme Court, where the Supreme Court has allowed for the termination of the pregnancy in order to ensure complete justice. So Article 142 of the Constitution, it gives an extraordinary power in the hands of the Supreme Court to ensure what is called as complete justice. Is that clear? This is just one example. There are a number of other cases for you to remember. So what is the answer here? It is a power in the hands of the Supreme Court to pass any order or decree in order to ensure complete justice in a matter pending before it. Okay. Come to the next question. Recently, the National Judicial Appointments Commission Bill 2022 was introduced. Recently also the government tried to introduce this particular bill in the houses of the Rajya Sabha, which is related to the system of appointment of judges in the higher courts. In this context, consider the following statements. Presently, the system of appointment of judges to the Supreme Court and High Court is based on collegium system. Is it true? Yes. And who constitutes collegium today in the Supreme Court? Chief Justice of India plus 4 senior most judges of the Supreme Court. In fact, there is one more thing that you have to remember. It is Chief Justice of India plus 4 senior most judges normally, but if none of those 4 senior most judges will become the next Chief Justice of India, because let us assume the Chief Justice of India is much junior in age to all these judges, then if none of these 4 senior most judges will next become the Chief Justice of India on the term on the present Chief Justice of India getting retired, then the next person who will be becoming the Chief Justice of India will also be part of the collegium. But if any of the Chief Justice or any of the 4 senior most judges is likely to become the Chief Justice, then it is only Chief Justice of India plus 4 senior most judges. Okay. So in general, it is Chief Justice of India plus 4 senior most judges, because whatever I am talking about is a very exceptional case. Statement 2, the collegium consists of Chief Justice of India plus 4 senior most judges in case of appointment of Supreme Court and 2 senior most judges of the Supreme Court in addition to the Chief Justice of India in case of appointment to High Courts. Is it true? The collegium is little different. For the appointment of judges to the Supreme Court, it is Chief Justice of India plus 4 senior most judges, and for the appointment of judges to the High Court, it is Chief Justice of India plus 2 senior most judges. What about transfer of judges from one High Court to another High Court? That is very important this year. That is also on the basis of collegium. And who is authority to transfer the judges of High Courts? It is a president, not the collegium. For the appointment also not the collegium. The collegium is only a recommendatory body. But however, here the recommendation is binding, but the appointing authority is only the president. The transferring authority is also the president. Okay, and the president will transfer the judges of the High Court based on the recommendation of the Supreme Court collegium, that is Chief Justice of India plus 4 senior most judges. So therefore, this particular statement is also true. The collegium recommendation is binding on the president provided there is a larger consensus of the collegium before the name is forwarded. Yes, because the Supreme Court said if among the collegium, if even 2 senior most judges have a dissenting opinion, then that is should not be forwarded, and even if it is forwarded, it is not binding. Therefore, it requires a larger consensus. So this is true. So choose a correct answer from the code given below. All are right? Okay, so the answer is all of the above. So I'll try to wind up the class by 4:50. Okay, I think there's another class, so probably I'll leave it 10 minutes earlier. But before that, I'll try to cover more than 300 questions. Okay. Consider the following statements. Yes. Consider the following statements regarding the jurisdiction of the Supreme Court. So how many of the students were also likely to attend the next class? Most of you. Okay, so I'll leave it 10 minutes earlier. Consider the following statements regarding the jurisdiction of the Supreme Court. Statement 1. All matters relating to the violation of fundamental rights of any individual residing in the Union Territory shall be petitioned only under the writ jurisdiction of the Supreme Court. All matters relating to the violation of fundamental rights of any individual residing in the Union Territory shall be petitioned only under the writ jurisdiction of the Supreme Court. Is it true? He may go to the Supreme Court or he may go to the High Court which is having jurisdiction over that particular Union Territory. So it is not necessarily only in the Supreme Court. So therefore, this particular statement is what? It is wrong. Any dispute between the Union Territory and the Union Government will be directly falling under the Supreme Court. Is it true? it is not under the original jurisdiction. Okay, so therefore not directly under the Supreme Court. It can go to the Supreme Court by way of an appeal, but not directly to the Supreme Court. So which of the statements given above are correct? Neither one nor two. Which of the following is are true with regard to the removal of the judges of the Supreme Court? Which of the following is true? The Constitution provides for a detailed procedure for investigation on the introduction of motion for the removal of the judges. Is it true? The detailed procedure is not given. The detailed procedure has to be brought in by way of a law that is made by the Parliament. And what is the law that we have right now? The Judges Enquiry Act, which talks about an enquiry committee has to be appointed. 3 members will be part of the enquiry committee. They will inquire, they will give the report. So this is all the detailed procedure which is only in the Enquiry Act, not in the Constitution. The judges can be removed only on the grounds of proved misbehavior or incapacity. Is it true? Yes. Is it defined in the Constitution? Misbehavior, incapacity? No. The removal motion has to be passed by special majority and has to be approved by the President in the same session. Is it true? Yes, this is true. So which of the statements given above are correct? What is the answer? 2 and 3 only. Come to the next question. Consider the following statements. In case of lack of quorum in the Supreme Court, the Chief Justice of India, with the prior consent of the President and with the consultation of the Chief Justice of the High Court, can appoint a judge of a High Court to act as an ad hoc judge. But here, what is this quorum in case of Supreme Court? Is it mentioned in the Constitution? What constitutes quorum? There is nothing which is fixed as per the law or in the Constitution. It only means when the Chief Justice of India feels that there are not sufficient judges in the Supreme Court to administer justice effectively. So whenever he feels that there is lack of judges, so then he can call for what is called as an ad hoc judge, a temporary judge. So this is true. In case of lack of quorum, the Supreme Court Chief Justice of India, with the prior consent of the President and with the consultation of the Chief Justice of the concerned High Court, can appoint a judge of High Court as an ad hoc judge. This is in general true, but one more information you should know: not any judge of High Court, but a judge of High Court who is eligible to be appointed as a judge of a Supreme Court. That is actually missing in the statement, but be clear about it. Okay. So any judge of High Court would not be the right thing. A judge of High Court who is eligible to be appointed. In fact, I framed this particular thing. It was there in my mind, so but it has been missed. So I'll make it correct, but you try to be very clear that it should be someone who is eligible to be appointed as a judge of a Supreme Court. So which High Court judge is eligible to be appointed as a judge of a Supreme Court? Only a person who has already served as a judge of High Court for minimum 5 years. Okay. So then it becomes the right thing. Anyways, I am making it correct, but you be aware of that also. But the way the question I have framed is not to check that, it is only to see the general procedure. Okay. So therefore I am making it right. The Chief Justice of India, with the prior consent of the President, can request a retired judge of a Supreme Court or High Court to act as a Supreme Court judge. Is it true? The Chief Justice of India, with the prior consent of the President, can request a retired judge of a Supreme Court or a High Court. So here also, a retired judge of High Court who is eligible to be appointed as a judge of a Supreme Court, only he can be called. And not only the consent of the President, the consent of the concerned judge is also required. Okay. But anyways, the question is not talking about that. In general, this particular statement is also true. So which of the statements given above are correct? So both 1 and 2. Consider the following. The Central Administrative Tribunal is a constitutional body established under Article 323A. Is it a constitutional body? No, it is not a constitutional body, it is a statutory body. The decision of the Administrative Tribunal can be challenged in the High Courts. Is it true? Yes, the Supreme Court has made it very clear in L. Chandrakumar case that the decision of the tribunal shall be subject to judicial review by the High Courts, and then subsequent judicial review can be also be done by the Supreme Court of India. So it is subject to what is called as judicial review. It can be challenged in what is called as the High Courts. So this is definitely true. So what is the answer? Which of the statement is are incorrect? What is incorrect? One only is incorrect. Which of the following best explains the concept of judicial review? What is the concept of judicial review? It is a power of the courts to review the actions of the other two organs of the state. What are the other two organs? Legislature and the executive, in reference to what? In reference to the, not the fundamental rights, in reference to the constitution, not necessarily the fundamental rights. So in general, whatever law that they make or whatever the executive action, it should not be in violation of the constitution. So therefore, the judiciary is nobody to question the wisdom of the other two organs as long as it is not in violation of the constitution. So sometimes a law can be bad, but unless and until it is violative of the constitution, the Supreme Court cannot declare that to be invalid. So judicial review is strictly in relation to what? Strictly in relation to the provisions in the constitution. So therefore, what is the answer in this case? What is the best answer? So it is a power of the courts to declare the action of only the legislature. So I talked about the general principle, but you applied it to this particular question. So when you apply it to this particular question, it is a power of the court to declare actions only of the legislature. So it is not only of the legislature. So therefore, you can eliminate this. It is a power of the judiciary to question the wisdom of the legislature. No, it is not to question the wisdom of the legislature. So you can eliminate that also. It is a power of the courts to declare the action only of the executives. So again, you can declare that to be invalid. It is a power of the courts to declare the actions of both the legislature and the executives as void if they are violative of the fundamental rights. This is just a subset of the concept of judicial review. This is right in this particular question. But in general, what is judicial review? Not necessarily the fundamental rights if they are violative of any provisions of the constitution. Okay, so therefore the answer is option D. Consider the following statements regarding the position of public interest litigation. What is public interest litigation? It's a litigation that is filed in front of a court of law by a person not for his own interest, but for the interest of some other people in the society. Somebody else is getting affected, so therefore he is filing a litigation. That's a public interest litigation. So therefore, the first statement is the principle of locus standi strictly applies in case of public interest litigation. It is exactly opposite. The principle of locus standi does not apply because it is not filed by a person who is affected himself. The public interest litigation can be used to challenge the violation of fundamental rights by any social action group or a public spirited individual, although they may not be directly have any interest in the case. Is it true? In fact, the Supreme Court has categorically said that public interest litigation can be filed as a writ petitions. That means public interest litigation can be used as a tool to challenge the violation of the fundamental rights, not necessarily by the affected person, but by any social action group. What does it mean by social action group? So for example, NGO is an example of a social action group. It is working for the welfare of the people. So that is a social action group. So yes, this particular statement is true. The term public interest litigation is well defined in the constitution. Is it defined in the constitution? It is not defined, it is not even mentioned in the constitution. So which of the statements given above are incorrect? What is the answer? 1 and 3 only. What is the provision to safeguard the autonomy of the Supreme Court of India? What is the provision to safeguard the autonomy? So what are the provisions which will safeguard the autonomy and the independence of the Supreme Court? While appointing the Supreme Court judges, the President has to consult the Chief Justice of India. Is it true? No, don't per se see that the collegium and all those things. It is only to see whether the autonomy is there. So among the given things, is the Chief Justice to be consulted? Yes, which means in fact based on their opinion only they have to be appointed. Okay. So this is yes protecting. It is in fact a UPSC question. The Supreme Court judges can be removed by the Chief Justice of India only. No. Who can remove them? The President, not the Parliament, the President. The salaries of the judges are charged on the Consolidated Fund of India, which the legislature does not have the power to vote. Does it increase their autonomy? Yes. All appointments and the officers and staffs of the Supreme Court of India are made by the government only after consulting the Chief Justice of India. As per Article 146 of the Constitution, all the appointments to the officers and staffs of the Supreme Court are made by the Chief Justice of India or any of the judge as the court may decide, not the government of India. So therefore, this is not wrong. So this is not right. So what is the answer if you eliminate these two? What is the answer? Correct interpretation. So all the officers and the servants of the Supreme Court shall be appointed by the Chief Justice of India or any of the judge as decided by the Supreme Court. So not by the government. So what is the answer here? 1 and 3 only. The power to increase the number of judges in the Supreme Court is vested in the Parliament of India. So who can increase? So presently what is the strength of the Supreme Court? 33 plus 1 Chief Justice of India. But who can increase it in the future? The Parliament can make an ordinary law, and by that law they can increase it. Which of the following are included in the original jurisdiction of the Supreme Court? 1. The dispute between the government of India and one or more states. Yes, yes, it is there. The dispute regarding election to either houses of the Parliament or the state legislature of a state. The dispute regarding the elections to the houses of the Parliament or that of the state legislature. Where this matter will go? It will go to the High Court concerned. So the High Court will have original jurisdiction in this regard, not the Supreme Court. A dispute between Government of India and Union Territory. No. A dispute between 2 or more states. Yes. So what is the answer? 1 and 4 only. Consider the following statement. Statement 1. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Can High Court declare the central law to be invalid? Now try to understand the kind of judiciary in India is what is called as an integrated judiciary. We do not have a separate judiciary to look into the central laws. So therefore the district court can also look into central laws, the High Court can also look into central laws, the Supreme Court can also look into the central laws. Okay, so normally this matter can be taken up by the High Courts, because High Courts may have original jurisdiction in this particular regard. So the High Court shall have the jurisdiction to declare a central law to be constitutionally invalid. Yes, they have the power to declare it invalid. But the problem is, if a High Court is declaring a particular judgment, it may not have application throughout the territory of India. So where it may have applications? Only in that particular state. So if a High Court is declaring a central law to be invalid, the law might be applied differently in different states. So in that particular case, who is a party to this? If a central law is declared to be invalid, the central government is a party to this. So therefore immediately the central government will move an application to the Supreme Court, and then the Supreme Court will decide the final verdict, provide the final verdict. But can the High Court declare a central law to be invalid? Of course they can. So that is definitely true. So no High Court. So then it is wrong. Okay. So no High Court shall have the power. So it is wrong. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Then who will call them into question? It is only the Supreme Court of India. Okay. So this is also wrong. So which of the statements given above are correct? It is neither 1 nor 2. But what is the ground on which the Supreme Court can declare a constitutional amendment to be invalid? On the grounds of violation of the basic structure of the Constitution, not merely on the grounds of the fundamental right, but on the grounds of violation of the basic structure. With reference to the Indian judiciary, consider the following statements. A retired judge of a Supreme Court of India can be called back to sit and to act as a Supreme Court judge by the Chief Justice of India with a prior, this I think we have seen it. Okay, so any retired judge of a Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with a prior permission of the President of India. Yes, but also with the consent of the concerned judge. So then it becomes correct. Can High Court judge, retired High Court judge can also be called? Yes, a retired High Court judge can also be called, provided he is eligible to be appointed as a judge of a Supreme Court with his consent and the consent of the President. A High Court in India has a power to review its own judgment as the Supreme Court does. Does the Supreme Court in India have the power to review their own judgment? Students get confused between the concept of judicial review and review powers. Judicial review means it is a power of the courts to look into the action of other two organs. Review powers of the courts means to review its own judgment. Does the Supreme Court has the review powers under the Constitution? Yes, the Supreme Court has got review powers under the Constitution under Article 137 of the Constitution. So it is not only having the review powers, on top of the review powers they also have what is called as curative powers. So these two things are directly given in the Constitution. In fact, review is directly given, but the Supreme Court of India said that they also have what is called as curative powers. But what about the High Courts? Do the High Courts have the power to review their own decisions? Yes or no? Is it given in the Constitution? It is not directly given in the Constitution, because most of the powers of the High Courts are derived from the ordinary laws made by the Parliament and the laws made by the state legislature. Accordingly, the Civil Procedure Code does give the review powers to the High Courts. The High Courts do have the power to review their own judgment. So that is definitely there. But it is not there in the Constitution. If it is saying Constitution, that is wrong. But here it is not saying as per the Constitution. They are merely asking that whether this particular statement is right or wrong. So what is the answer here? Which of the statements given above are correct? Both 1 and 2. $298. Okay, what is the doubt? Which one? A dispute between Government of India and Union Territory. Yes, it is not a federal dispute. No, it is only the federal dispute is under the original jurisdiction. So if it is not a federal dispute, then it will not go to the Supreme Court. Only the federal dispute falls under the original jurisdiction. So here the question is asking which of the following are included in the original jurisdiction. To be part of the original jurisdiction, it should be a federal dispute. So therefore, where this dispute will go? If there is a dispute between Government of India and the Union Territory of Delhi, it will go to the High Court of Delhi. So there they can challenge it, and further appeal will lie in the Supreme Court because it is not a federal dispute. Clear? If suppose there is a dispute between, let us assume, Union Territory of Delhi and Haryana, so there in this case the dispute will go where? It will go to the Supreme Court because it is a federal dispute. Okay, this question just try to solve this. This is a UPSC question. I will just take the class for another 7 minutes. Okay, so I will try to cover 5 questions because then I can tomorrow complete up to 400 questions. Okay, so consider the following statements. The motion to impeach a judge of a Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Enquiry Act. It is again subject to the discretionary power of the presiding officers. So not just the Speaker, if they want to introduce in the Rajya Sabha, the Rajya Sabha chairman can also reject it. So here it is saying cannot be rejected, so therefore it is wrong. The Constitution of India defines and gives details of what constitutes incapacity and misbehavior. No. The details and the process of impeachment of the judges of the Supreme Court of India are given in the Judges Enquiry Act. Is it true? Yes, it is given in the Judges Enquiry Act. So this is true. If the motion for the impeachment of a judge is to be taken up for voting, the law requires a motion to be backed by each House of Parliament and supported by a majority of a total membership of the House and not less than 2/3 of the members present and voting in the House. Is it true? Yes. This is the majority with which it has to be passed. So what is the answer in this case? 3 and 4 only. With reference to the Constitution of India, consider the following statements. Statement 1. The government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from the recognition of advocates. Who shall be recognized as a practicing advocate or who is recognized as an advocate in our country is based on Advocates Act. Now, as per the Advocates Act, only an individual can be recognized as an advocate, not a firm. So, a firm can have a number of lawyers, but the firm itself cannot be recognized as an advocate. So, therefore, this area makes this particular statement wrong. The Bar Council of India has a power to lay down the rules relating to the legal education and the recognition of law colleges. What is the status of the Bar Council of India? It is a statutory body established by the Advocates Act, and it is a Bar Council of India which will give recognition with regard to the colleges, and also it will determine the curriculum for the law degree and all those things. So, this is definitely true. So, what is the answer here? The answer is option B, 2 only. The Bar Council of India has recently made some rules. The Bar Council of India can make rules under the Advocates Act. Now, recently they have made rules allowing even the foreign advocates to come and practice in India. So, they wanted to establish foreign law firms in our country, and they wanted to liberalize the profession of law in our country. So, therefore, this has been done. So, I have framed one question that is related to current affairs, which will come at a little later stage. Consider the following statements pursuant to the report of Hutch and Sanyal Committee. Hutch and Sanyal at that point of time, before 1971, was the Solicitor General of India. So, pursuant to the report of Hutch and Sanyal Committee, the Contempt of Court Act 1971 was passed. Is it factually true? This is factually true. You cannot do anything about it if they ask such things. It is factually true. I also do not know who such this Hutch and Sanyal, but I have to search, then find out the answer. So, therefore, these are all the questions that we should not be concerned about. So, this is true, but there are certain areas you should be aware of in this case. The Constitution of India empowers the Supreme Court and the High Court to punish for the contempt of themselves. Is it true? Yes, of course, they can punish for the contempt. These two courts are considered to be court of contempt, or they are court of records. Now, which article gives this contempt power to the Supreme Court? Article 129 of the Constitution. Which article gives the High Court the contempt powers? Article 215 of the Constitution. So, both the courts can punish for their contempt. So, this is definitely true. This you should be aware of. The Constitution of India defines civil and criminal contempt. The Constitution of India only gives a contempt power. It nowhere defines as to what is contempt, and therefore, it does not define what is civil and criminal contempt. So, all these things are given only as per the Contempt of Court Act. It is a Contempt of Court Act which classifies contempt into civil and criminal contempt. In India, the Parliament is vested with the powers to make laws on contempt of court. Is it true? Because contempt of court is an item in the union list. So, therefore, who will have the power to do this? Only the Parliament will have the power to do this. So, therefore, what is the answer here? What is the answer? Answer is B. 3 is wrong, remaining are right. Okay, so the answer is option B. Consider the following statements. The term misbehavior and incapacity is well defined in the Constitution, which is a ground for removal of the judges of the Supreme Court and High Court. Partially true, partially wrong. So, therefore, the statement is wrong. The Parliament is authority to remove the judges of the Supreme Court. Who is authority? The President of India, not the Parliament. Okay, sorry. As per the Constitution, every state in India should have a High Court of its own. The Constitution is saying that every state shall have a High Court. It is not saying that every state shall have a High Court of its own. That means every state should come under the jurisdiction of a particular High Court, not necessarily a separate High Court for itself. So, therefore, this particular statement is also wrong. So, what is the answer here? Which of the statements given above are incorrect? What is the answer? 3 only. Come to the next question. Consider the following statements. The number of judges in case of the High Court is determined by an act of Parliament. Is the Parliament will determine the number of judges? In case of Supreme Court, it is determined by the Parliament. In case of High Court, it is determined by a presidential order. So, these are all the areas you should be very clear. So, sometimes we are carried away, we see that whatever is for the union, we consider to the state. Whatever for the Supreme Court, we consider to be the High Court. No. So here it is only done by the President of India. The President can pass an order and through that order they will determine the number of judges. The additional judges in case of High Court may be appointed by the Chief Justice of the concerned High Court in consultation with the President. Now try to remember this as a principle. In case of ad hoc judges, and when somebody is called upon, the retired judges to called upon to attend the proceedings in the Supreme Court, in both the cases it is done by the Chief Justice of India in consultation with the President and the concerned judge. But in case of the Constitution, when it comes to the appointment of the acting judges or the ad hoc judges or the temporary judges, here as it is said, or additional judges or the acting judges in case of the High Court, it is always done by the President of India. So who will appoint the additional judge and the acting judges in the High Court? It is the President, and anybody who is appointed as such a judge shall not hold on to the office for more than 62 years. So these two things you try to remember. So therefore the additional judge in case of High Court may be appointed by the Chief Justice of the concerned High Court in consultation with the President is wrong. So who appoints the judges? It is the President who will appoint these judges. So that is wrong. The High Courts have original jurisdiction on all civil and criminal matters. Is it true? The High Court does not have original jurisdiction in case of criminal matters. The High Courts have no original jurisdiction with regard to criminal matters. All the criminal matters shall go where? Only to the subordinate judiciary. But after the punishment is given, then they can come to the High Court for a way of an appeal. So therefore no original jurisdiction when it comes to what is called as criminal matters. But yes, there can be some original jurisdiction in case of civil matters. That depends upon the law that is made by the Parliament. Definitely no original jurisdiction in criminal matters. So therefore this statement is wrong. So what is the answer here? Which of the statements given above are incorrect? So it is 3 only. So alright, so with that we are almost done with judiciary. There are I think some 20 questions that is pending, which I will take it in the next class. So in the next class, after I complete the judiciary, then lot of other topics are also there, small topics, but assume that each and every topic 1 questions are likely to come. So the major part is done. So tomorrow I will try to cover as much as possible, maybe around 400 or 425 questions I will try to cover. Okay. So if you have any questions, you can ask me after the class. So now I will wind up because there is a next session that is coming up. Okay. Thank you very much. Outside.